Good afternoon. My name is Ronaldo Hilton. I'm the chairperson designee of the New York City Loft Board. Welcome to a January 31st, 2019 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of future multi-dwelling buildings from commercial and manufacturing spaces to rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. I want to first thank folks who are braving their time out in this weather. I can probably go on the record as saying this is probably the coldest loft board meeting ever held. And for the one brave soul in the audience that came and look at us, that's great. Thank you. All right. Before we begin, Ms. Boston has some announcements to make.
So two things. The first is that the deadline for the project guidelines was extended for a month until, a little more than a month, until February 28th, 2019. And my understanding is that as far as Ms. Woods and Ms. Roslin is working on comments. So again, if you want to look it over, I know it's a very technical document. I had a lot of trouble with it, so I'm not a technical person at all. But if you want to say something, please send comments to them. The other thing is that we wanted to inform you that the City Council has scheduled an oversight hearing regarding loft law issues for February 11th, 2019 at 10 a.m. February 11th. February 11th. So from Monday. At 10 a.m. 10? From after? That's interesting. How do we...
It's a public meeting.
Yeah, it's a public meeting. It's the housing committee, housing and building committee.
Can you send out location details?
Sure.
All right. Before we dive into the rules, Ms. Boston circulated a document containing proposals for the meeting with the attorneys, which is scheduled to take place on February 14, 2019 at 1 p.m. at Spectre Hall at 22 Reed Street. The first issue is the proposal of the attorneys to have a panel discussion. So at this time, we'd like to entertain any comments on that. Do we have any comments on that proposal? Is it a good proposal? Is it bad? Do you think it's fun? Yes.
I think the panel sounds good. From what I read on the sheet, they'll still spend 3 to 5 minutes interviews for themselves, and then we're sticking to primary residence and protected occupancy.
That was what we asked them to come in and
That
address.
sounds great.
So you give the chair the approval to cut anybody off in case that divert from anything else. But we'll discuss it, right? All right, board? Sure.
Is the presumption that, did I hear you say that we're working on a 1 p.m. start time?
For the meeting with the attorneys,
For the board meeting on February 14th.
honestly, I don't remember. I think so. I believe so.
Okay. We've been having a little difficulty with
I know.
our 1s and 2s recently. Actually, somebody showed up here thinking the board meeting was yesterday.
Why?
Because jet lag. When they were told that the board desk that it was at 2 today, not 1. So we really got to get the communication started.
So we'll do that, right? But as a general rule, the 1 p.m. is for the private sessions when we do have one. In a case like today where there's no private session, we start at 1. So the whole idea is that we come a little earlier meet instead of a later one. So where there's a private session, we always going to meet at 1, as a general rule, right, Ms. Paulson? As a
Yeah.
general rule, we always meet at 1, except sometimes it will be the private sessions that meets first. So when there's no private sessions, the board actually will begin when it's at 1. Unless there's some odd instance that, something that comes up and we have to make that change. As a general rule, but we apologize for any misinformation that went out before.
So on that day, we have, on February 14th, we have 2 hours allocated for the lawyers. What else are we doing? Cases?
No, we're not doing, it's even on.
It doesn't sound like it's on.
This one's got a green light.
It's on when you're not.
Okay, anyway, so yes, and then I figured we could have follow-up discussion on what they presented and maybe move forward on the changes to the protected occupancy. But maybe not, but we could have some sort of discussion. But no, we're not doing cases, the cases are on February 21st.
Any other comments about formalizing next February 14th meeting? So the
Okay.
panel is okay, right? The panel is right. Okay, great. Okay, second, the board asks for a breakdown of questions concerning protected occupancy. Ms. Balsam has drafted some proposed questions. Are there any comments?
It would appear that as you set this up, questions presented, if the answer to the first question is no, where do we go from there?
Well, if they don't have to prove the primary residence of the unit prior to the board granting an application, then there's no reason to discuss what time period they would have to prove, right? So I guess from there, we would go to what is now question 4. So we go straight from 1 to 4. But I think we should have them address those questions.
Oh, yeah, no, I'm just, it seems, yes.
Right, these are things that, I tried to break it down to what I thought would be helpful to the board for them to address. The ultimate decision as to which way to go is of course yours, but that's, here we're talking about asking them questions and what we want them to talk about.
I was thinking they would maybe provide examples of cases. I always learn best from real stories, and if there are cases that aren't pending, I thought they might share some. In architecture, we call it case studies with law, I don't know what you call it. Case
Precedent.
studies. Precedent. So that I can understand what I'm interested in with primary residence and protected occupant is sort of the issue of prime leasing, tenant, subtenants. Because in real life cases that I know, or my neighbors in my building, that sometimes it seems like the subtenant one is sitting there and someone might be, a tenant might be subletting and they live in Los Angeles. I want to understand the rights that those subtenants that are actually living in the space would have versus the primary VC with a lease, but a lease that's like from a few years ago. I'm trying to understand the relationship, who has rights as tenant.
Who has rights under the loft law?
Yes.
Okay.
So I don't know, through the case study example, like you would, there's a case study, I think that's finished, like a couple that was a lien and there was a subtenant. You could-
No, it was the niece.
Niece.
Right? It was the niece?
Yes.
Yeah.
Like cases like that really help me to understand real scenarios that I hear that I don't know how would be resolved. So it would be helpful with the lawyers if they have questions.
Okay. I will ask to provide examples.
Can you paraphrase how you're going to add that question?
I think the question is already there, it's question 4. And I will ask them to provide examples regarding prime lessees and subtenants.
I think it might also be useful. You had expressed to me the question of, well, how does this differ from the way things were in terms of the lawyers and cases 5 or 10 years ago?
In reference to discovery requests?
Yes.
Yeah.
I would like to see a question addressing that added to.
Does anybody have any comments on that? Is everybody okay with that?
I agree with that. That's a good question.
Can we make it last though? Because I think the other issues are more important.
What she's saying is that she would just make that towards the end, of enough front to us, was address the more important questions.
I have
Well,
a question about
depends
that.
on.
I knew you were going to come with that, but you understand, she thinks, Ms. Wilson, paraphrase, she thinks that the more pressing questions are what she has here.
Is the more,
Those are also the questions that the board asked the lawyers to address in November.
is the bigger question that we're making rules, and then there's these discovery cases that in these lawyers, either side, in their mind, are big cases that then change how the rules are interpreted. So it would be helpful to understand how they read these discovery cases and if that's affecting rules. I don't know. I'm just thinking from the perspective we're trying to modify the rules, and I want to understand there's the rules and then there's case history, and I don't understand how they.
So this rule is about who gets to be protected under the law, not how they prove it, which is why I'm hesitant to move into what they do or don't have to prove. We first have to decide who's going to be protected. Then how they prove it is a different issue. And I really don't want to get bogged down in discovery and lose sight of the main issue, which is who are we going to protect? Who do you want to protect? That's what we're talking about here. The board has already said, we definitely want to protect more people, right? We want to make changes. But you asked to have these people come in to talk about who to protect. So I think those are the primary questions they have to address.
With all due respect, I'm not quite sure I agree with that. Insofar as the question that is uppermost in your mind, I think, with regard to the proposal that's been kicking around in various forms now since September of 2017. In terms of who do we want to protect, the board is listening to me object multiple times that there was a policy in place that was followed for 30 years that was clear to everybody, and the notion of who we want to protect really stems from some event or sequence of events in 2014, 2015. And it's probably best articulated in the second version of the opinion 7 on Mormon Street. But I have maintained adamantly that the board's new interpretation really reversed 30 years of policy without ever having any public input or hearing on the matter, and that's created a lot of problems.
But that has nothing to do with discovery, right? That goes to the issue of who should be protected. So I think your position is that we used to protect more people than we protect now, and we should go back to the way it was, regardless of what kind of discovery requests are made. So why are we going to get bogged down in a question dealing with how discovery requests have changed over the years?
Sorry, I just want to make sure, I think I misinterpreted. So discovery is the act of like how much proof do they have?
Yes.
Okay. Versus, I think I was thinking of rules versus case history and how, because in Department of Building, like for architecture, we have code, but then there's, an examiner starts to interpret something one way and then that becomes like a precedent. So I think similarly in law, you have rules and then you have case history that makes sense.
Interprets the rules, that's
And
correct.
so it would be helpful because we have the two lawyers, if there's a little bit of the case history that's affecting the rulemaking, or yeah,
Right,
right.
I mean, I think everybody.
But maybe I was misinterpreting, that's what I thought he wanted, but
No, one of the, jump in if I'm wrong, but one of the complaints that we've gotten from tenants is that because the board has allegedly shifted in terms of who's going to be protected, that they are now forced to provide a lot of documents that they didn't use to file. And I have repeatedly asked for examples and have not, like before and after, and I have not gotten before and after examples.
the tenants,
The
we wanted
tenants.
the tenants to give you an example.
Well, they are claiming that it is much, much more burdensome on them, which it may be, I don't know. But I have asked for examples, and I got some information, but it was not a before and after picture. And I really want to see a before and after picture so I can understand what it is that they're talking about. Because it seems to me that if you are filing for coverage and protected occupancy, a whole lot of the information that you are submitting for coverage is going to also go to protected occupancy. Now, if it's just a protected occupancy claim, that's different, right? Because the unit's already covered. So it could be that there's something there that the board should discuss, but I haven't gotten any of the feedback that I really feel I need to.
So that would be the potentially the lawyer coming in on the tenant side would have some past case studies that are closed that are examples of that, right?
Of how discovery has changed.
And
Yes, but
the plan.
But again, we need to decide who we're going to cover. Who we're going to protect. So our units are covered, people are protected. So that's the issue, and we need to stay on task. We can't get sidetracked on this other path that says, and it's a lot harder now. Right?
Well, to make that more specific, maybe is there a case that where discovery prevented your client from covering, something where we can hear what a case.
Tenants have said that they cannot afford to meet the discovery requests, so they have settled cases. Tenants have said that. My response to that is that oath will make the owner pay for it if the tenant can't pay. That's what the oath rules say. I don't know what's going on there. I'm not privy to all of that stuff.
Right.
But that is feedback that we've gotten. But again, we need to focus on who we're going to protect. That's what they're coming in to talk about. Who should we protect? Why should we protect them? Etc. How the proof is there, I think, is a secondary issue. And I don't, we can, if we have time, I'm all in favor of letting them talk about it at the end. But I really don't want to get sidetracked and talk about discovery for 2 hours, and we never get to the issues, which is, should you have to prove primary residence? And if you do have to prove primary residence, what time period should that be? And then what should happen between subtenants and prime lessees, where the prime lessee is there claiming protection.
Well, okay, I'm just throwing this out there, but, so maybe at the end, could there be some questions, I guess they're leading questions, but can you give us an example of a case?
You can ask them whatever question
A
you
case
want.
that's already closed, where a tenant was harmed by, is there a way they can show us an example where a landlord was harmed by, can we learn something from their actual case?
I'm sure you can. And I'm sure they'll be willing to talk about it as long as the cases are not pending.
Right. Is that, so I guess I'm saying, at the end of the questions, which is what you're saying, could we have something where they actually give us some specific, or let them know to prepare it in advance, some specific case they might want to share with us that's closed where they feel like something.
I will ask them to try and cite two
Chuck, I
specific
don't know
cases that
that-
are not pending.
I think that would be helpful. Again, with all due respect, I have to take issue when we talk about an alleged change in the policy. The board, in its revised opinion of 79 Lorimer Street, detailed quite thoroughly that it had changed its policy. This is not a theory. In part, this confusion got created, or not confusion, this distinction got created out of another piece of what, in my opinion, was wrong with the chapter amendments that were part of the expansion of the Loft law in 2010, because when the board had never had a deadline on filing for coverage of registering buildings. It was in the 2010 legislation that there was going to be a deadline 2 years after the substantive rules were made. In an effort to allow applications in buildings that were already covered to add additional units, we split apart a coverage application and protected occupant. And that's really, from my vantage point, where the trouble started. And we did that without the board discussing it or any kind of public hearing or any notice to the public. We've seen cases where lawyers have protested that they weren't even aware when, at the time the case was heard, that they need to provide certain proofs. And there was a system in place that worked very well for 30 years, and I question why we're abandoning it over and over again.
I don't want to get into that because I think that that's something to be discussed after the lawyers make their presentation. For now, I'd like to finalize these questions and move on to the other rules that we can maybe move forward with today. Because we're going to have lengthy, I'm sure the board will have lengthy discussions after the attorneys come and speak. So,
Is there a question like you want to ask them? I don't even know were either of these lawyers involved in the Lorimer case.
At least one of them was probably.
Do you want to ask them specifically questions, what they feel is the ramifications of the outcome from the Lorimer Street case?
I guess
by the way, there is still pending litigation
Oh,
on
there is.
Lower Street. It's just in the courts, not in.
yeah, it's out of our hands. I guess one thing I would ask is that maybe you could distribute to all the board members the opinion and the order that passed.
Sure, yeah.
And I guess I still have to register a concern that your interest is in how should we have the rule now in determining who's covered, whereas
Protected.
whereas that's kind of, in my opinion, going past without really thinking about it, the question of how did the original scheme function and why should we change it?
If you want to ask the attorneys that, that's fine. Do you want me to add a question that says that?
Yes, I think that would be helpful. Pardon?
I'm not sure how that gets us to where we need to be today. Okay.
Well, I guess where it gets us to where we need to be is that maybe the whole notion of changing this language, regardless of how to change it, is not such a hot idea.
So in essence, you're saying that perhaps we should just rewind, if you will, to 2014, 2015 timeframe and say, hey, we were doing it this way for 30 years and it was working and we were protecting more people. Let's just erase this last couple of periods where we kind of got a couple of wheels off track. And in essence, you're saying that perhaps the answer that we might be getting from these attorneys is actually already in front of us. We're just not.
Probably not from all of them, but certainly the scheme was very clear.
Yeah, but that was before my time, unfortunately.
The unit, once the unit is registered, to become a protected occupant and to make it a covered unit, you needed to prove residential use during the unit. Once the unit was registered, if the owner had reason to believe that it was not being used as the primary residence of a protected occupant, the owner took them to court. It was a grounds for eviction. I see that you distributed it in today's package 208-1.
Mr. Carver asked me to distribute that, and I distributed it for the section C, which is the succession rights. He couldn't be here, so he asked me would I please give that out, so I did. But it happens to have the eviction rule too.
Right. So the notion that unlike rent stabilization, I have to prove the unit was my primary residence before it's covered, or for any period prior to registration, is, in my opinion, wrong.
So part of understanding why so looking at the different phases, that's what Chuck's saying, and then understanding what worked and what didn't work about each of, and how it went from sort of point A to point B. So I think we learn as much. What I'm hearing you say is we're going to learn as much from how we went astray, or how it changed, or how as to where it needs to go. Does that make sense? That was not very articulate, but learning from the past, right? Learning both the good and the bad, and sort of trying to
think of something that's analogous. I can't. We had a system in place that works extremely well for 30 years. Neither owners nor tenants complained about it. Then at some point, a series of changes were made.
Because of the 2010 law, you're saying because of the 2010 law had 2-year.
Whether the 2010 law made it necessary or whether it was a justification offered for changing the rules. And as you know, it's not just me who feels this way. The oath judges have consistent, in many instances, not 100%, but in many, many instances, the oath judges have objected to the board's interpretation. The board has modified the oath judges' opinion. So it's not just in my individual point of view.
So with all due respect, yeah, I hear you. We just have to kind of move on to the purpose of today's meeting for now. And I think, we're not dismissing anything, but we just want to be able to accomplish what we came here today to do. And so that discussion for that, right? So,
sure, in that regard, my only request was that we add a couple more questions to frame the issue beyond just, well, how should we change it?
Okay. I think that'll be good.
Yeah.
So, thank you, Mr. Mayor. So we'll now continue our discussion on the proposed rule changes, and Mr. Paulson will continue this discussion.
So, looking at the document, which was a set of an excerpt of some of the rules that I had prepared for the November 15th, 2018 meeting, we had already voted, I believe, on page 1. So we would be on page 2, which is, this is the extension rule, so it would be 2, and we were talking about good faith efforts, and I have been asked to prepare information about good faith efforts and to get information from decisions. So I went back and prepared a chart of 12 decisions. I'm sorry that some of them are very old, but at a certain point in time, the decision maker on extensions went from being the board to being the executive director by administrative determination. So it's harder, I mean, the ones that I did, I have filed, but the ones that other people did, it's harder to go back. And only those cases that are appealed, usually a denial of an extension, are board decisions. So it's harder for me to find more modern stuff, but I think the ideas encapsulated in these cases are pretty much what we're talking about when we're talking about good faith efforts. So to the extent that you might want to add language to the rule, that's fine. I think the language in the Salva case is very good. But whatever.
Was I the one with that?
Yes.
I think one, this is great. It's actually interesting that you say it's hard to find from previous executive directors information. That's part of my point, is like, how are they making these decisions? So the one thing I think I wasn't clear, I'm going to try and, this is great that you prepared this. When I sent you a copy of, I'm used to in the apartment buildings, landmarks, for example, I have to have there's a material checklist.
Right.
It's an internal document, and as a filing architect, I have to meet every single criteria that they keep track on their end, and I keep track. I can see. I have to keep supplying them information until we're all clear. And so I guess I meant that if there's a complementary internal document that's like a checklist that could be pulled at a FOIL request or something, that could be seen by others, like here's how that executive director made this decision, because in good faith, there were all these things that were met.
So
You might already do that, I just haven't seen it.
I do not have a checklist, and if I did have a checklist, I would say that that is not disclosable under FOIL as attorney work product. Okay, so let's start with that. So no, in my opinion and experience, the Loft law, anything pertaining to the Loft law, checklists don't work. The whole point is that every situation is unique. So, to the extent that you're talking about what kinds of cases, where has the board granted extensions, here are some examples, and I think the examples are pretty clear in terms of the kinds of things that people have to do. I mean, I had an extension request that I recently granted where the person, within the 90 days of assuming ownership, had actually filed the Alt-1 and a narrative statement and had already scheduled a conference. So, I mean, to me, that person's working very hard to legalize this building. And they had also had conferences with tenants offline, which they're free to do, but
Yeah, I thought the document also was super clear and very helpful and speaks to exactly what you're saying, that it's case-by-case basis. But and then where the gray area is where someone claims they're making a good faith effort, but or it doesn't seem like they're If there's a discrepancy between what they believe they're doing and what the law believes they're doing, correct?
Right.
And then, so that,
And also remember that tenants are served with the extension application and have a right to answer. And they quite often do, and, they'll scream bloody murder. No, you can't give them another extension, and here's why. They say they did this, 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 and this, but they didn't actually. So, we take that information, assuming it's timely and correctly filed, we take that information into consideration as well. So, I thought that your concern was that you wanted to put some language into the rule.
I think
to
there's
kind of
that,
guide,
right, there's
right?
that too, because an internal checklist could just be dismissed by
Yeah.
the future director, I guess. But the fact that you went to the past and it was hard to find more recent information,
because
which
there aren't
kind of
board
goes along with
decisions.
what Chuck was saying, that in 2015, things changed, their interpretation changed. Like, it would be good to know.
I think this rule, changed in 2006.
something.
Yeah, it was like 2006 where it shifted from the board making decisions on extensions to the executive director making decisions on extensions. So,
How exactly did that come about, Chuck? Where it went from the board making the decision to the executive director?
I think it was agreed to as part of the tightening up of the process. Martha's the great historian of,
No, I think there was some concern about the delay in bringing the cases to the board, and that the executive director could do it quickly. And that way, the parties would know whether they were in compliance or not in compliance.
Was that also a component of how we think things might have gotten switched in 2015 with who was protected, or is that?
No, it's just
separate.
in 2006, there was a major overhaul of this rule in 2006, and it used to be, and I still can't wrap my head around it, that people could apply for retroactive extensions. So they would come in and say, well, I'm past the deadline, but I did good stuff a year and a half ago, and you should say that, the board should say that I'm in compliance, so I can charge rent for that period of time. I can't exactly figure out how it worked, but it seemed very bizarre.
It was a little bit like being able to come in to the library 2 months after your book was due and renew it. It was the concept of an extension was not part of the 1982 Loft law. It was added when the law was renewed in the 1990s, and it took the board a while to come up with a rule, and at first the rule was just like, yeah, bring it on any old time, apply for an extension.
Yeah, even without notifying the other parties, right? I mean, the owner could do it, the owner could just apply and not even tell the tenants.
It depended on the duration of the extension. You were applying, I think it was for less than 3 months, or less than 30 days. It was one type of application that didn't require notice to the other side, and then there was up to 3 months, and then there was up to a year.
So I think, the language that I highlighted from Matter of Salva, I thought was very, and it's cited in all of the later cases, I thought was very good language. And if you wanted to incorporate that language into a rule, I think we could do that. So the language that I'm talking about is, if the circumstances show that the IMD owner intended to try to meet his obligations but failed, then the extension must be granted. But if the circumstances show the owner's intentions were otherwise, for example, to delay in the hope that he or she might avoid the obligation to legalize or to impose sufficient inconvenience on the tenants, that some or all of them abandon their units, then the extension must be denied. So, somehow taking that language, maybe the first part of it, looking at the total circumstances, and does it show the owner intended and tried to meet his obligations as a definition of good faith?
Well, on that point, it seems to me, one of the things we need to take into account is the way the draft is currently written. It's really a two-pronged test, correct?
Well, it's good faith efforts and circumstances beyond their control. Is that the
Right.
question?
Yes. And we don't necessarily look to one or the other first, we just weigh them both.
No, I think we looked at circumstances beyond their control first,
Okay.
because there would be no reason to think about good faith efforts if they can't prove that it was circumstances beyond their control.
No, we would be the other way around, that you want to,
The reason is because for extension applications, you have to file before the deadline expires. So a lot of times, these buildings are already out of compliance because it's a new building or it's a new owner. So theoretically, an owner can't apply for an extension because those deadlines expired 10 years ago. So the rule allows for 2 exceptions. In the case of an owner who is in compliance, who wants to file, they have to do it before the deadline expires. So one, they have to prove it's beyond their control as to why they didn't meet the original deadline. So that should go first. And then it's demonstrated, well, are you now making good faith efforts to legalize the building, regardless if you're in compliance or not. So that's how we think about it.
but if an owner did not make a, so quickly you're right on my mind, right? So if an owner does not make a deadline, because of something beyond his control, but first he's showing that he attempted to make the deadline, and then his reason for not making the deadline was something beyond his control.
I don't know, we don't usually think of it that way. We usually do the circumstances beyond their control first. And even when I think probably statutes said that would be also, right?
Can you quantify those? Beyond your control is normally landmarks or BSA. I wonder how many of the caseload are in the landmark district or do you have zoning?
A lot of them are, a lot of the buildings are in landmark districts.
Because couldn't someone, an owner, not meet the deadline, be making what looks like a good faith effort, but have created the circumstance themselves?
Absolutely, and there was an example in one of the cases where I think it was Kengen, where they had decided that they were going to add to their Alt 1 information about commercial use on the manufacturing spaces, right? So they created that, right? So they were right, they didn't meet their deadline.
The variance request, it's not a self-created hardship.
Right. Right. As opposed to we had another building, and I don't recall whether they were in compliance or not, if I'd asked for an extension, but just to use it as an example where they needed to apply to, I forget who does the plan, but I think it's city planning for a waiver for rooftop recreation, right? So that's not BSA, but that was because the roof could not support rooftop recreation. That was their argument. The city planning ordered, and they did in fact get their waiver, but if they had come to me to ask for an extension, I certainly would have considered that a circumstance beyond their control. They didn't make the roof, right? It's not a new building that they built it that way.
Right, that was probably if city planning's involved, I think it's like a tenant space requirement that is also
An open space.
Right. It's not their responsibility that the rules require the particular entity.
So, I mean, that's the way that we tend to look at it. We tend to look at circumstances beyond the control before we get to the good faith.
What were you saying about self-created hardship? Like, could that be written? I find there's sometimes bias against tenants. That language like that, that's for a tenant. That sounds a little mean to the landlord, like self-created hardship. theoretically, if we added, I mean, I think that's an important point, that someone can't just using the system to add something on that's going to cause delays, so they don't have to spend money, so they don't have to bring their building up to code. That's a real issue.
Wasn't that, is that, you need to tell us, so I would guess that that is a big part of the hardship of any loft conversion. I mean, everything I've seen in my 25 years in New York is that it's a hardship for a landlord to bring their building up to code because even under 7C, right? And a lot of times it's because they themselves have created those units which don't work, the egress doesn't work, the sprinkler system doesn't work, blah, 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 because they didn't do it with a professional or with a contract. It's just sort of, it's all very ad hoc.
Right.
And then you end up with this situation, with a building full of people who are living in spaces that are impossible to be brought up to code. So the whole loft law sort of in and of itself deals with landlords who have self-created hardships, right?
I'm not sure you're correct that it's the landlords that have done the work.
But somebody's done the
tenants
work.
that have done the work.
Or
With
the landlord's
acquiescence.
Right. It's still their responsibility, it's their building. If a tenant were to file with the Department of Buildings to do work, they need to get the landlord's signature.
Right.
So it's always the landlord's responsibility.
So the code, the building code requires, puts the onus on the owner to maintain the building. So yes, the ultimate responsibility falls on the owner of the building. A lot of the defense you hear at court in buildings violations is that I didn't do it. The person who's living there, converted or legally converted, did this work without my knowledge. But that doesn't take the onus away from the owner. It is their responsibility by code to maintain their building. So in that sense, they allow it to happen, whether without their knowledge or with their knowledge.
Isn't that sort of the crux of the issue that then, say for the building owner, the easiest thing would be to kick out all the tenants, rip everything out and start from scratch, right? But we don't want that.
Right.
So it's illegal.
Correct.
So we're
Thanks to the law.
And other laws.
okay. Yeah.
I think Heather has raised a very interesting point, and when, for example, the butter and egg people moved out of Tribeca, because Hunt's Point was, owners were sitting with vacant buildings that at that point in the 1970s didn't have any real value. And along came these artists and kindred spirits and did a lot of work. As time went on, I think
Sweat equity.
Sweat equity. And I think as time went on, it's more common in the past 20 years that owners, we're trying to share.
Yeah, we're not doing that. You're talking now.
Yeah, it's like town hall. In a lot of the buildings in Brooklyn, in the last 20 years, let's say, the owners are more like, hey, this vacant space is not like something I have no idea what to do with. This is a valuable commodity. So in some of the earlier buildings, which were also smaller, it might have been the tenants who created more of the problems to legalization. But in the larger, newer buildings where the value of this, hey, this residential law conversion is pretty good, it may be that, it's an interesting thing to think about. And really look at it.
I would like to point out that that work would be the work required to make the building residential. So it is one of the requirements to apply for coverage. So it would be hard to penalize an owner for doing that work, but at the same time cover a tenant
Right, but there are, I guess my point, there are situations where work that was done, as an example, the configuration of a floor of a loft building is such that it is impossible to make it code compliant, let's say.
Yeah, I guess.
And so
It's
that
always
could,
going to be possible?
right, so that could potentially be a reason that someone can't make their deadline. Like there are a couple of these examples where they hired an architect, they couldn't make it work, they had to hire another architect, they couldn't make it work, they had to hire another architect. So it's possible that could go on indefinitely if there's no answer. I mean, what if there's no answer? What if they can't get to the exit without cutting somebody's unit in half?
Well, we have had cases where the owner did have to take away space from people's units in order to provide egress. We have a case where the owner put in a back stairs, and the tenant was very upset that he or she had to lose space, but they had to lose space because that was how, the other choice would have been to leave. I think, it's preferable to have a smaller space, but you get to stay.
Right.
I'm sure if it were me, I wouldn't have been happy about it, but we have had cases where tenants needed to lose space for legalization, but it has to be for legalization. It can't just be because the owner wants it.
When the original law went into effect, putting the buildings in Soho Novo and Chelsea, I don't think that I can recall one building where it was difficult for the landlord to bring these buildings up to code. Now, as far as these buildings in Brooklyn, Williamsburg, and I've been into a few, I think there they tend to be more complicated.
Well, they're huge buildings.
Yeah, one is a huge building, and sometimes they're very odd spaces, like that building with the garage door.
Yeah.
But nonetheless, the difference is that, as I recall, going back to 1964, artists moved into these spaces, and landlords didn't give a damn whether they did or not because the manufacturing district was leaving the city. Soho was the felt and feather business in the city of New York. Felt hats and feather, that was basically their main industry there. Yeah, felt hats. So I think we have to give a little more consideration, depending on, see, what I'd like to do when I see these buildings coming up in Brooklyn, I like to find out what they look like.
Right.
So generally I go online and see what they look like. Sometimes I can't even, it says 269 something or other, and I get 284, and I can't even get the front of the building. But I agree that it could be far more difficult to do that. But then, yes, the big difference is the landlords now know who they're renting to.
Right.
They're not just renting to anybody because the space is empty. They're renting to people that they know that are living there.
Well, I don't know that they necessarily always know that they're living there. I think part of the confusion was there were a number of folks who rented to work, and then there was a considerable amount of illegal conversion that took place. And that's happened a lot in Brooklyn.
No,
So you look at these buildings, and I've been in a number of them already, a lot of them have been illegally converted, and that's a situation that the owners have to reckon with. So
No, I think you're right. There are a lot of, as we look at, there are a lot of buildings where all kinds of stuff goes on in the building. And then the views and stuff goes on in the building, and somebody says they're living there. And maybe they are, and maybe it's a big issue. So I agree.
When you say illegally converted, what do you mean by that?
So the zoning was N, and the buildings are clearly marked for manufacturing use. Someone comes in, they're creating an artist studio without the living conditions supposedly in place. And then over time, they moved in a bed, they start to use the bathroom as a normal bathroom, but maybe a communal bathroom, or for whatever reason, even if they had a bathroom within that apartment, within that unit itself, it's not residential. It's supposed to be a working lot, and yet they started to convert those, and that's what happened a lot in Williamsburg, East Williamsburg, all those different areas.
And is it your sense that this was done without the owner's permission or now?
In some cases, yes. So the owner is renting out to people or to an entity, and so then people started to convert. Whether I'm sure in many cases, and there are buildings that we're familiar with, where the building owner pretty much understood the situation that was taking place, and in certain cases facilitated that illegal conversion. But in many cases, their argument has always been, this is a building that's designed for work. People, I can't stop people from staying overnight, I can't stop people from staying multiple nights. If someone wants to move in a bed, there's no way for me to track that, and so people ultimately end up creating that type of condition. That happens throughout. It's the reason why that's why there was legislation that was passed on illegal conversions. They were increased, I think, 5 years ago to $25,000 per unit in order to discourage the illegal conversion of those buildings. So a lot of that takes place now.
So, yeah, it is, as a concrete example, my office was in a building in East Williamsburg, and which is commercial. We're on Bogart Meadow, and
9.
huh?
Not 9.
No.
Okay.
So there's 3 buildings on this corner. They're all commercial, and a couple tenants started, staying, living, whatever. Nobody wanted to lose their office space. We have a reporting label. We have serious professional businesses in this building. It's not, whatever. And the landlord finally did evict this tenant who was living there because everyone complained, like this person, it says clearly in the lease, no living, right? So that's an example of a landlord who is on top of things and, and who maintains the building for the leases, for the zoning, for whatever. So it is a partnership between the tenants and the landlord, is how I see it. Like, so if you need both. You need tenants who want to be commercial tenants, and you need a landlord who wants a commercial building.
I agree. An unfortunate situation isn't as easy always, but I agree. Like that ideal often condition.
But for the ones where it's already covered under the loft law.
Right.
If we could just get that to those that are covered. Do we want to make changes to the language in this section?
So, yes,
So what do you suggest?
I wanted to bring it back around. That was an interesting discussion, and I think it does point to the inertia that might come from the landlord side and the tenant side to not just fix the building, right? There's some built-in inertia because it costs money and effort and blah, blah, blah. And so it goes on for years. It goes on for years, and they're both kind of safe because they're not going to be kicked out, so they get to live. So the system itself makes it tough, and we're fighting the inertia. So I just want to make sure that when we give an exemption, I guess that's why I was interested in the checklist on the other side, which is internally, because I can imagine, and an exemption seems like a really nice
Extension.
extension seems like a really nice thing to give a landlord if we see that they're working in good faith. But if they then just go right back out of compliance, I also think it's important on our end to track them so they don't get to disappear in the system and linger for another 20 years. Like they're coming out into the light again. Let's track them. I like the idea of like they can't just fall away and then we don't follow up. And I think that's why I like your enforcement.
Right,
plan.
that was one of the purposes of the enforcement plan, was to try and get that.
Right. So I just think, maybe you're doing it already, but I thought so maybe the checklist can't be FOIA, but maybe the board can see the checklist so we know.
Well, I don't have a checklist. As I said, every situation, it seems to me, or in my experience, all 2.5 years ago,
I know they're
every
unusual,
situation-
but there's got to be some level of, like, landmarks buildings, for example, are completely all different. There's all different kinds of weird scenarios, and they've managed a way to come up with a strategic checklist to tackle it. And I don't, so I just thought it was a good example, being that we're in the Department of Buildings, that they're, you know, to have some, it's a language that we're familiar with, those that are.
And do you want this in the rule? Because we're talking about what.
Well, so I guess I'm
language
asking
to
for
put in the rule.
both simultaneous, like it's, I know it's rules, but I don't want to leave it at rules. I just want to catch, like if we do give someone another chance at an extension and then they fall back and fail at needing it again, that the point is to get through the system and make the building safe, so just always catching them at times so that it doesn't linger. That's what we're trying to resolve, right? So
No, we're trying to decide what we're going to do with this rule right now.
yeah. So
I mean, I can come up with a checklist as I go through the extension applications and I'm processing them. I can try to come up with a checklist to say, here's what I look at.
Right.
But in the meantime, if we could figure out if we're going to leave this as it is or we're going to add language to it, because you were very concerned about good faith efforts not being adequately defined.
Or I think what you mentioned was it was hard to find the information once the executive director was making that decision.
No, what I said was that the reason that you have both cases is because what you asked, it's easier to find cases where the extensions were denied. Because when the extensions are denied, it's much more likely that the owner is going to appeal and those appeals will go to the board.
Okay.
For the grants, where they're granting, it would have to be a tenant that would bother to file an application to challenge a grant of an extension, and that's going to be rarer. So that's why some of the cases are so old.
Is there a penalty to, just, I'm pretty sure the answer is no, but I'm going to ask it anyway. Right, so say an owner has had a building for a long time, the market starts to change, right? He sees the value in having these tenants, and he sells the building as such, which is causing the new owner, so the new owner is the one filing for the extension.
Correct.
But the previous owner is the one who has basically caused the problem and then cashed out.
Correct.
So, is there some way, does that come into account ever?
To the extent that the new owner is allowed to ask for an extension, yes.
But the old owner, there's no way to discourage that from happening?
Well, one of the reasons that we're undertaking the enforcement plan is to try and get these buildings that haven't done anything, to try and get them moving, and hopefully we will be issuing fines to some of these buildings, and that's really the only way that we can hit them. Theoretically, we could go into court, but I'm not sure that we can go into court. The tenants certainly, there are
I'm sorry, we're such a noisy bunch of people, it's fine.
So, to the extent that we have owners that have been around a long time and haven't been moving, that's who we're targeting. We're targeting the oldest ones, right? Okay. We're targeting the ones that have been in the system the longest and stalled. So that's where we're starting the enforcement. We have been moving forward with the plan, we'll have a report. But that wasn't for today. But here, the issue is, we have this language here, it pretty much tracks the statute, and I think that there was some concern among the board members that it wasn't sufficient, and how we're going to make it sufficient, so. Are there different sirens? Can you tell the difference between a fire and
A little bit.
Yeah?
Small trucks versus big trucks.
That was a big truck?
That was a big truck. It also sounds like a big fire.
So they all come to everything, even if it's not, right?
Well, especially maybe today, because it's
Yeah,
pretty
yes.
brutal.
Yeah.
I'd like to go back to this language you made in Salvo.
Yeah.
I think we're still kind of sort of in that same ballpark. I sort of like this, and I'm wondering if we could strike some sort of agreement to go ahead and move forward with that language. You said you could envision this language being
I think you could
inserted
tweak
in-
this language to say, good faith efforts is, for an owner to demonstrate good faith efforts, they have to show circumstances that they intended and tried to meet their obligations, but failed. So I think that's good language. I like that language. It's broad enough, but narrow enough, and it gives some leeway. So I thought that that was very good language.
Does anybody object to trying to move forward with getting this, to inserting this language?
Can I try waiting for the microphone for the sake of the minutes?
Just move the mic.
Is it voice? No, it's
Doesn't get recorded.
it's the.
The acoustics in this room are awful.
I asked Elaine to send me the cases that are in these summaries. And it's interesting reading. The other thing, I asked her to do an hour before the meeting, which obviously she can't do for a while, would be to send out some examples of cases that were denied, because we're really looking here only at the glass half full versus the glass half empty. So in the language in Salva, and I didn't realize you were I didn't meditate on this as much as I would have if you suggested, take a look at that bold language and give some thought as to whether it would be good in the rule. It didn't. So,
Sorry.
tried to meet his obligations but failed. I try to exercise, but I haven't done anything in a year, right? It's different than I tried to exercise, but then the hot water heater burst. So the mere act of failing I don't find persuasive.
You think it should be tighter language?
So I think we should be more concerned with the mere act of trying. I mean, what defines trying? So the whole thing is that he didn't meet the obligations, right? Can we tighten up this language? We just have to get to it, because otherwise we're going to debate this for another hour. So, I mean, using that particular language, can we just make suggestions on any change that you want to have in that particular language, or should we just dump it? Or can we tighten up that language and put it in? Do you think it would be appropriate to help clarify what good faith is?
I'd like to hear what the lawyers have to say about that.
Well, you heard what Helene had to say. You want to?
All right, we'll run up.
Okay.
Going down the line.
Go. He wants to know what
Well,
you think.
the thing is a non-lawyer, but it's burdened by the fact that so many of my relatives and friends are lawyers. And I know how imprecise language can be. And I remember reading the original rules would come down, and the lawyers are sort of watching their tail by saying and 3 or 4 ands in the same sentence to make sure that everything is all clear.
Okay.
So my question is, does this language, I agree with Blaine and Richard on this, but does this language seem to be okay, lawyerly wise?
Okay with this
Okay.
answer. But if you have suggestions, that's why you are the board. You make your decisions.
We are in agreement that.
Okay, that's right. I didn't hear from Martha.
I'm just reading the first sentence where it says, if the circumstances show that the IMD owner intended and tried to meet his obligations but failed, then the extension must be. I think the good faith effort, the key words are the circumstances show that the IMD owner intended and tried to meet his obligations. I mean, if, for instance, an owner has to do something to one part of the building, let's say in the cellar, and Hurricane Sandy happened, but before Sandy happened, he purchased the equipment, had the contract for the plumber to actually do the work. The day that Sandy happened, I think that owner intended and actually tried to do the work. But if he didn't buy the equipment, didn't have the thing set up, but his vision was that he was going to install this plumbing system because it was necessary for legalization, then that's not enough. I think the point is that I think the language is fine. I would end it there and not say then the extension must be granted, because I think that ties our hands. But I think if this is what we actually look at when the issue is being analyzed and the case is being written, I think that's fine to add the language to clue the public into what it is that the staff is going to look at when trying to determine whether they've exercised a good faith.
Would you just strike out that last phrase?
Right, I would say
Or
we're
use the
trying.
word can rather than must. Or use the word can instead of must.
May.
No, I would just leave it there.
I would leave it at for example.
The phrase is to define good faith effort, and I think that tried and whatever that language is.
The owner intended and tried to meet his obligations,
Yes.
but failed.
What about instead of try, so tried's a little wishy-washy, just in the end, I mean, so,
May attempt.
Made affirmative, took affirmative steps.
So what Martha's talking about is like something concrete, it can't just be,
Made affirmative.
Action.
Yes.
Made affirmative steps.
just right, exactly.
Two notes. One is that the summary itself is perhaps 400 words. The report and recommendation from the oath judge in the case is 39 pages.
Well, but there were a lot of issues in
A lot of
there that
issues, yes,
that were
yes.
not
I
applicable,
understand.
so I just took out what we.
Well, I understand that. No, I'm not suggesting that, you know, this is the one-word theater review. This is a hit where the real line is, I was hitting myself in the head after I left the theater because this was so bad or something like that. But what I would propose is, A, I would ask that you send salvo around to everybody, the unexpurgated version. And also, why don't you come back to us at the next meeting with proposed language to consider for insertion?
You mean for this piece that we just discussed?
Yeah.
I thought we just came up with a reasonable thing for this. I mean, what do we need to debate this particular? I mean, how?
Well, I would, by the way, I would take out try to meet them, I would say will meet.
Well, no, I like the idea of somebody taking concrete steps to meet their obligations. I think that, you know, because we're talking about that they did something, they have to show that they did something, right? That's what good faith efforts are. So I like the idea of saying not just that they tried to, but that they actually took steps.
No, but I would like, I mean, I don't think setting, I mean, Mr. Delaney, I'm not wishing to put it aside, I'm just saying, I think this is simply enough where we've already debated this and to come back to, send stuff back around, to go through another round of debate and so on with this. I don't think it reaches that.
Well, where would it fit into the extension, if we now switch to the red?
I'm looking at
What I'm suggesting is that we give the staff time to tweak it, to bring it back, rather than spend another hour on it.
Okay, so,
Unless you're in a position right now to make that decision
and then we
You
just
make
look
the
at it.
decision, not us.
or whatever it is that we want to include. so that
I
we
mean,
can
do you
make
think,
progress.
Helene, that we could come up with that language real quick to see what would, then of course we'll be recirculated. But we can probably just.
Hold on.
No sense.
It would be a new
It
sentence
would
at the
be
end,
good
right?
faith effort would include or
Right.
include, affirmative steps toward.
You mean making a different, new sentence
It
than
would be a new
just?
sentence at the end, I think.
So it would be 3 ayes instead of, it would be aye, and then there's 2 ayes, and it would be the 3
No, no, at the end of 2I,
At the
right?
end of 2 ayes.
Right, so the way that 2I is structured,
Okay.
right? It says the extension could be granted by whomever, right? If the person shows that the necessity for the extension arose from conditions or circumstances beyond their control, and the person has made good faith efforts. And then we have a sentence that says, examples of conditions or circumstances beyond the person's control include, but are not limited to, blah, 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 right? So then at the end of that sentence, it would be, good faith efforts, right? The standard for good faith efforts is that the IMD owner intended and took concrete steps to meet his or her obligation, but failed, right? So we would add that at the end. So that would be the proposal.
So this is, I think, line 10, where the sentence ends, reasonable access to an IMD unit.
Two I. Oh, yeah, we could put it there too. Oh, that's the corroborating evidence. It should be an I, not II, because II is talking about what kind of proof you have to have, whereas I is setting out the standard that you have to meet. So we could add something to the end of II to say, you know, taking concrete steps would be, you know, showing invoices or whatever, hiring an architect. You know, that's, to me, that's a huge factor. Well, but it's not going to be just that, you know.
It seems self-explanatory to me, like a concrete step with a concrete step.
Yeah.
Hire someone, file something. Put a wall, town wall, something.
What's the decision on this?
That's progress. We're figuring out
Is
where it fits.
are you going to draft something certain, or are we deciding on that?
Whatever the board wants this. Huh?
Okay,
It's easy enough to be able to move forward and
do we have enough on this to move forward? Have we at least come to an agreement in principle under the language that we're going to put there, right? And where we're going to put it?
I'm not clear on either where we're putting it or what it is.
Okay, so that's exactly what I want from Ms. Wilson. If you could just say exactly what we're going to put where, and let's move on.
So at the end of I, we would add at the very end, good faith efforts,
One.
two I. Right, it's the first paragraph on the page. Okay?
Yeah.
So, just trying to figure out how the best way to proceed. We want to say an owner can show good faith efforts,
You would say that up above what we're talking
we
about.
say examples of such circumstances are.
Then I would
I agree.
again, language, examples of affirmative or good faith efforts include.
Mr. Chairman, can I make a suggestion? We take a 5-minute break and give the staff a chance to see if they can reach
I agree.
a single.
Let's take a break. Thank you. We are back on the record.
Okay, so we are proposing to add as a after the last sentence currently in 2I, to show good faith efforts, an owner or responsible party or holder of the owner's interest, I have to figure out which one it should be, must show it intended and took concrete steps to meet its legalization obligations and failed.
Should that and be a but?
I was going to say that.
Okay. But failed. And, okay, let's start with that.
Thank you, Ms. Bolton.
Can you read that again?
show good faith efforts. An owner or responsible party must show it intended and took concrete steps to meet its legalization obligations, but failed. We should take out that. Must show it took. Yeah. Let's take out the intended. Okay, to show good faith efforts, an owner or responsible party must show it took concrete steps to meet its legalization obligations.
And the rationale for removing intended is,
Because who cares what they intended? We want them to actually have done something. They have to make good faith efforts. Intending to make good faith efforts should meet the standard.
So we have consensus on staff putting that language in, great. We don't have to vote here. Do we need to take the vote on that language?
You're changing rules.
I'm sorry, have a comment?
Well, yeah, I know I was only suggesting concrete, but tangible is maybe a better word.
Okay.
Tangible versus concrete.
Yeah, I just looked up the definition. Synonyms to concrete, is that are real, specific, particular. Concrete sounds a little odd.
Lawyers, tangible versus concrete.
Specific, I think, is the best out of all of them. Specific steps.
I thought affirmative steps would be more.
Oh, affirmative steps.
Affirmative.
I like affirmative.
Thank you, I stole that one. Affirmative.
Because it also implies moving forward, right?
Yeah.
affirmative steps.
Affirmative steps.
Need a motion?
Took affirmative steps to meet its legalization obligations, but failed.
Need a motion? Motion to,
Make a motion.
To accept.
to accept the
I make a
language.
motion to accept the language that we just read into number 2I.
Thank you. And the second, Mr. Hernandez, Ms. Rivera.
Mr. Barrett,
Yes.
Mr. Rouge,
Yes.
Mr. Hernandez,
Yes.
Mrs. Torres,
Yes.
Ms. Roseland,
Yes.
Chairperson Hudson.
Yes.
6 in favor, 2 absent.
Check doesn't get us that.
Then you're on.
Sorry, Mr. Dewey.
Jenny knocking on the
How
door.
did you just get that message?
She knew you would be in agreement.
7 in favor, 2 absent.
And then we thought for 2II, we can add in, the fourth line down. It says, for example, copies of documents from the Landmarks Commission or the Board of Standards and Appeals, or an architect's statement, or invoices for the purchase of construction materials.
Why do you say copies of documents? Just why do you say-
Because it says copies of documents now. I mean, they can't,
No,
they
not
can't
necessarily
necessarily,
copies, but
necessarily
I was
have.
just thinking documents, just say documents.
Oh, we could say.
Just take out the word documents.
Okay.
There's no such thing anymore as copies.
The original versus the copy.
Yeah.
So I
That's
think,
legally true.
Everything's a copy now.
well, the presumption, I assume, is that someone wouldn't be submitting an original signed contract. They would be submitting a photocopy or like a
Yes.
facsimile, right?
Yes.
But it doesn't, so does it make a difference, I guess, legally one way or another if it just says, so it says as an example, a document from the Landmarks Commission, then the question is, does it have to be an original document or can it be?
Right, and I'm saying in this regard, context probably doesn't matter, right, for
I
that.
don't think it matters.
All right, so we'll take out copies of, so it would be, for example, documents from the Landmarks Commission or the Board of Standards and Appeals, or an architect's statement, or invoices for purchases of construction materials.
I don't think the invoices for purchases would make sense, would it? Because they have to get certified if I needed to move forward and then have to go forward. I mean,
An invoice
What do you
meaning
mean?
the transaction's already happened, or is that's some kind of estimate?
this would be prior to building, to buying any construction material.
Right, because they're getting an extension.
No, not necessarily, they could have been working, right? I mean, the whole idea is if they're making good faith efforts, they've been working, right?
Well,
So
they
how do
have
they
to work
show?
until they file with the Department of Buildings and they can't do that until.
No, but they can get an extension after they file for a permit.
Oh,
And
really?
after they pull the permit, they can get an extension for the 7B deadline.
Oh, the last one.
Yeah.
Got it.
So,
Okay.
And then they can get 2 for the C of O deadline. After they achieve 7B.
Oh, so they might be under construction,
So they could be under construction.
When,
Invoices, but they could show a contract with.
yeah, I was
They
gonna
could,
say,
yes. So what do you want to say?
Or insurance, I mean, they could show.
all right, so again, presumably then they would not be doing the work themselves if they have a work permit, it needs to be done by a licensed contractor.
Right.
So they would more likely be providing copies of their like plumber's license, things like that, like showing that they have a professional team on board.
Rather than just an invoice.
Like, oh yeah, I went out and bought some plywood,
Uh-huh.
you know.
I'm gonna use it in my den at home. But I think suggesting highlighting purchasing construction materials is more likely to be.
Dangerous.
Okay, so I mean, we don't have to add anything to this section at all. We could just leave it the way it is.
Whose request was it for a specific example?
I think maybe I wanted examples to just show the public what, or an owner what, and to make the law more transparent. But I don't want to list one that'll get us in trouble.
Okay.
So,
Just leave it as it is, except take out copies of?
Because the reason,
so documents from landmarks and Board of Standard Appeal, that's easy, that was already sort of.
yeah, and I think you should
That
leave
is
it there. It's already there, right? So, yeah, the reason why I want to include construction materials, because you could be using that stuff for anything, right? It doesn't specifically earmark it for that location.
What about,
You could show a contract between an owner and a contractor, which is what any condo board or co-op board makes you show all the time.
contracts would make sense.
So contracts with licensed professionals?
Not licensed professionals.
Contract.
It says licensed professional, that's what we get work. Contractor has to.
You should have seen the guys that did the
I don't
work in my
understand, isn't the
place.
contractor licensed?
you know, I wouldn't, the more specific you get, the more possibility that something will go wrong in the
Yeah.
whole process.
So maybe there are just 3 things.
These are getting, this is just.
They're just examples, yeah.
So we're muddying up by trying to get too specific and trying to include as many examples as possible.
Oh. All right, so we're going to leave it as it is? Just leave it as it is? Okay, fine. So we'll just make that change to I. Yeah. Okay.
And we took out copies of.
You're taking out copies
And we're not
of.
voting on this.
Would you like to vote on it?
No, I
Okay.
don't need to vote on any of this stuff.
Yeah,
Okay.
I think we can move forward and then we're just going to take the vote at the end and agree
Oh,
upon
just
that.
at
Is
the end?
that all right?
Yeah, okay.
Yeah,
Okay, that's fine, yeah.
thank you.
Okay, on the next page, I don't know why I'm seeing this with glasses.
Where are we?
We're on page 3.
We're on 3, okay. Got it.
Okay, so this is how to file for the extension. And they have to use the standard form. And then we added here, include a statement from the licensed architect or professional engineer estimating the amount of time the owner needs to obtain a certificate of occupancy for the residential portions of the building. The statement should include an overview of the work needed to legalize the building and units and the time necessary for completion completion of each phase of the work. So,
Just plans be better than overview.
I'm sorry, say that again?
Plans, which is not terribly specific, would that be better than overview?
Well, they may not have drawn plans,
No,
though.
no, but the C plans doesn't necessarily mean they have to be drawn.
Sounds good. Like, you know, first I'm going to do this, and second I'm going to do
This is
that.
what
So we
Oh,
need-
I see.
Yeah, good.
You're not using state,
The
these
game
are not
plan.
construction plans. These are-
Right.
It seems to me that this hinges on what deadline I'm seeking an extension for.
I think no matter where you are in the process, you could have, you could include a statement estimating the amount of time you need to obtain the city vote. I mean, even if you're at the very beginning, or you filed the O1, or pulled your permit, or you're at 7B, right?
Okay, so let's say, just for example, I'm at 7B.
Right.
Therefore, there are plans,
Right.
there's the narrative statement conference.
Right.
So, I could just submit those and an estimate from a licensed professional on the amount of time.
Yes? No?
Not the narrative statement. I would say
Oh, well,
that
we
you would
don't
have
need
to, we would have to tell us what's necessary to complete it, not necessarily
Right.
what he's done and what he's going to do, just what he plans to do, or what else is outstanding to be done.
I mean, this really goes more toward how much time do you need, right? So one of the questions that had come up in earlier discussions was, well, but how long are we going to give them, and you know, how much time should we give them? So I put this in here, we put this in here to address that issue, that we wanted something from an architect or engineer to say, here's what our estimate is as to how long this project is going to take.
So I would say the both overview, it works with the licensed architect or professional engineer. It goes together. So when you talk about a project, you talk about the scope of work. So it could be scope of work instead of overview, which is basically 12,000 square foot of new roofing. You put a price to it, you put a time period to it, you understand the special contractor to do it. And at the beginning of each project, we would do that as part of the project. You outline what the scope of work is, you assign responsibilities to the different subcontractors, and then you assign a schedule to each task, and it tells you how long the construction period is, and that goes into the contract with the contractor.
So my only question is, though, for somebody who's at the very beginning of the process, a new owner who's buying a building that has done nothing, where the prior owner has done nothing for many years, do you think within 90 days, maybe depending on the size of the building, it's reasonable to ask for a scope of work?
Within 90 days of hiring a professional.
Okay, but they have to ask for the extension within 90 days of purchasing the building. So I didn't want to go overboard and ask them for things that might be too hard to get within the 90 days. Although I have to say, I just got one where they had already filed, they filed an alt-1 within the 90 days. They filed an alt-1 and narrative statement within the 90 days. So obviously it can be done. And that was a large building.
I would think anyone, well, if you're
Well,
buying
it
a building,
depends- it
that's
depends
a
on
Loft
how-
building, you're gonna be able to move, because you know you have to.
As long as you get access. That's,
And you hire the right architect, I guess if you don't, and that's a delay in your own making. Yes, I guess if you were prepared going in, it could take 90 days to hire an
Well, I have had owners argue with me that, you know, it's been 90 days and, you know, we've contacted these 3 architects and we're still waiting to hear back.
Well, so
And I
part
said no.
often.
What we don't know is when did they start?
Yeah, I mean, I said no to those extensions.
But it can be, so often an architect's scope of work is based upon the construction scope of work. So it's one of the first things that one does when meeting with a new client is like you determine what the scope of work is going to be, because, you know, I can't give you a fee to say, how much is it going to cost for me to design this for you if I don't know what I'm designing. So that's part of the process. So you should be able to get a scope of work that kind of comes with the architect.
With hiring the architect.
With hiring the architect. So now whether or not that's the final scope of work then comes later when you hire the like after you do the drawings, you go through the DOB process.
As you learn more in that.
As you learn more, and then the contractor comes on board, and depending on your budget and their price, the scope of work may go up and down. So it could be anywhere from a month to a year before you know what that final scope of work is going to be. But generally speaking, you know what it is right off the bat.
So when I get extension applications, a lot of times, and pretty much I won't grant it without it, they have to have, for the new owners, they have to have something from an architect that said, you know, they've hired an architect and they send me the contract with the architect that says I'm going to survey the building, I'm going to draw up the plans for an Alt 1, I'm going to serve and file a narrative statement, I'm going to attend narrative statement conferences. And so it's all sort of very loft law oriented, not so much construction oriented. Is that a scope of work?
No, usually the scope of work describes the actual construction.
Okay.
So this would be so I see. So it's not the overview of the construction work needed to legalize the building. It's the overwork of the professionals. It's the overview of the professionals' work needed. So that's what
Overview of the plan.
Well, so make a plan, do a plan.
Let's not use plans at this point.
It's
It's a lot of work.
I mean, it could be, you know, we could say the statement could include a scope of the construction work needed to legalize. I mean, I'm okay with putting that in there. I just don't, I didn't know the terms.
That's the one that's going to be difficult to get within the time frame, because
Okay.
as Julie just said, so oftentimes also professional contracts are done in 2 phases. So the first phase would be like, you're going to pay me $5,000 to figure out what you need to pay me for.
Right.
Yeah,
I'm
I'm doing that on a project. It's like the pre-design information gathering, collect the survey.
Right.
Like, figure out all the zoning, all the issues with the historic district. Fact finding.
Should we say an overview of the steps needed?
It seems to me that this is a place where if I'm a new owner, the old owner hasn't done anything, and I'm starting from scratch, I would be able to provide a certain kind of narrative. Whereas if I'm looking for an extension of the TCO, I should be able to provide a more specific narrative. So maybe part of the problem with this paragraph is it's trying to be a one-size-fits-all. And
Just get or statement there.
I think this is a generalized statement. You're trying to get information from the owner of what has he done to legalize it. Not necessarily plans. It's not necessarily, it's maybe the architect went to the building to survey, or I met with engineers to figure out the elevator situation. I met with DOB on ADA. It doesn't have to be anything, it doesn't have to be a plan. It has to be, what are you doing to legalize this building? And it should be general, and it should be up to...
General, right.
So can I just suggest instead of the word overview, maybe explanation? Statement should include an explanation of the work needed to legalize.
Well, and that's not a bad word, but, you know, this is the problem with the language, is that it's, that you look up a word in the dictionary, and you find 5 or 6 different definitions of it. So no matter what language we use, it's going to be open to some kind of interpretation. I don't know.
Does it capture the essence of what information we're seeking to get?
I
I mean,
think
you know,
yeah, I think that's
we use narrative statements for some other process, which is actually a very good terminology.
yes.
So I would say this, based upon that overview, is the wrong word because it implies everything. So when I read that, I say, okay, I'm expecting you to bring me the whole package, with nothing missing.
Yeah, that wasn't the intent, so how, is an explanation a better word? A statement should include an explanation, or a preliminary explanation?
So you don't want it detailed? Because I was thinking the statement should include a detailed narrative. I think I like that word, detailed narrative, of what is needed to legalize the building and units.
Again, what if you don't have a detailed narrative yet?
Okay, so wait. Let's not use narrative, because narrative statement has a very specific definition under the rules. So we can't do that.
Absolutely.
Detailed explanation. Do you want to use the word detailed?
Synopsis?
Yeah, from what you were describing, it's like an estimated schedule.
Yeah.
It's like a preliminary, but preliminary might not be the right word because
Like,
it might be in milestone 3, so it's not preliminary, nothing.
Remaining work? Well, it may not be remaining, I mean, it could be that it all has to be done.
So, detailed estimate?
That sounds good.
No? What? No? So,
Estimated schedule, well, what we're
Synopsis, a condensed statement or outline as of a narrative or treatise. The abbreviated.
are you reading?
She's got
Oh, okay.
dictionary.
Is that Google?
It's Webster.
Webster, okay.
So where are we? Statement should include what?
I vote for synopsis.
A detailed synopsis of the work?
Is that like oxymoron?
It's not an 8th grade word.
It's one of the bad words that confuse a lot of people, which is just as well.
No, it's not just as well.
No. I mean, the whole point is that some synopsis of that has to be put forward in order to have this thing go forward, to get an extension or whatever.
estimated schedule
A
and
description, a brief description of the work.
brief description.
Because if you're not asking an owner to come forward, if you're talking about a new owner, a new IMD, it's going to be very hard for that owner to get a full narrative, a full plan together in 90 days.
Right.
You're simply trying to find out what steps have you taken to legalize. So if you say, I've got an architect, I got an engineer, I've surveyed the building, I have gained access to all the tenants' units. These are all things you want to know. This would be helpful to the executive director in making their decision. A brief description is probably.
I would like the word description, but not brief. Just take out the word brief. It's a description.
Description.
Well, but Michael, I think that I think what we were getting at here was the time frame for how much time they need.
I think we're just fighting over the word overview. Yes.
Yeah, but the purpose behind asking for this is to say how much time do they need to do this, right? Because we have to give them a time frame for the extension. And right now, we have to actually ask them for a date, which to me is like ridiculous. How could you possibly give a date?
So, can I just make another suggestion?
Is there a checklist?
Maybe if we do it like this, can you just follow me on this, right? So, must include an estimate, instead of statement, an estimate from a licensed architect or professional engineer, setting forth the amount of time the owner needs to obtain a certificate of occupancy for the residential portion of the building. The statement would include a description.
The estimate.
Excuse me, the estimate, yes. Should include, or must include, it's not should. Well, in this case, you're saying what you need from them, right?
So it must include what?
And then it must include a description.
Brief.
No, no description.
It's long.
You want to read it to children.
If they want to take as much time as, the more detail is the better, right?
Well,
A lot of
detail.
But nobody wants to put
Yeah,
detail.
so I looked up
Nobody wants to read.
overview and I just, like, when we were talking about it, I just looked at
Well, I
The more
would say
detail,
just
the
to-
easier it is for her to make a
When
decision.
she suggested scope of work, it's usually DOB makes you write like a little paragraph scope of work, so to me, that's a brief description.
Yeah,
Brief
brief description is a
work.
DOB, it's a building code thing.
Overview and timeline, and, you get the timing, you stick with the word overview. Overview, I don't see the issue.
The language instead of the aesthetics of the building.
For something that provides time.
Over language all the time. What was I putting in there? You said description?
All right, then.
Overview is fine too, I'm fine with that.
So.
Explanation, inclusion.
Are you against description? Is description
Is it,
okay?
yeah, are you,
Include-
I mean, are you strongly opposed to the word description here?
No.
Yeah, so can I,
So can you read the
A
first
spoken or
one?
written representation or account.
What is it, description?
It's a definition of description.
Yeah.
is it all right?
Spoken word.
All right, so it's-
Written representation.
I mean, the
or
main
account.
point is a professional that they have to retain.
Yes.
Get them.
Right. And I want to make, so we'll go over the language again, but I want to make one more suggestion to replace the words, licensed architect or professional engineer. I mean, I was thinking of us putting in consistent with the building, New York City building code, put New York State design professional. And that's,
Only changed it.
We just-
Oh, we can change it.
We had had
Oh, that was-
design
that
professional,
was
we
my-
had changed it.
Yeah, I agree with you.
So, I don't want to come with an architect from Arkansas that does, that comes in here and try, you're from Arkansas? That comes in and then give them some stuff, and then they say, oh, this guy said this, but he had no knowledge of New York State, laws of New York City.
Well, not as a Tammy, but this is part of what is so interesting about this, is this gives all these definitions. And there's
And that is in there, right?
the definitions are in here, right? And so that, and I was thinking about that earlier in the meeting, that when something is, like, whenever you're reading the zoning resolution especially, and it says a story or a basement or a this or that, you can't, it doesn't mean whatever you want it to mean. You always like flip back to the first section and there's a very specific meaning to every single word.
And I just want, my point though is that New York State design professional is defined as a New York State licensed architect or engineer. I want to make, unless we're going to just put New
Well,
York
we
State.
could say New York State
New York State
licensed
license.
architect or professional engineer.
Okay, we could do that here, but it just makes it longer, but fine. But I want to make sure this license qualification here is to New York State. Is that all right? Which would you prefer, licensed design professional or the New York State design professional or the licensed architect or professional?
Well, I don't remember changing it to that before meeting.
Probably. Because I know originally I had written
You
licensed
probably-
design professional.
Take a look at
and
page
had some-
5.
Page what?
Page 5?
Yeah, page
It's probably
5,
somewhere else, right?
E, in red. little
Yeah,
red.
licensed design professional, yeah.
Yeah.
Because I had asked what a licensed design professional was.
Yeah.
And the answer I got was it's
It's defined within the building code, right?
Well, we should use the same language.
Well, here we have an architect or engineer licensed and registered to practice under the education law of the state of New York. That's what we got to need, so.
All right, we should use that language, absolutely. We should have two different languages to describe the same thing.
Just have a license.
It's going to say, must include an estimate from an architect or engineer licensed and registered to practice under the education law of the state of New York.
Just license to practice in New York, right?
Well, we want
New York
to,
State.
okay, so license to practice in New York State. Okay, so then we're going to have to change the other.
Yeah, and then we can fix that language. Which says,
So it would be, an application for an extension must include a list of all residential IMD units in the building and must include an estimate from an architect or engineer licensed and registered to practice in New York State. And then I sort of got setting forth the amount of time.
yes, the owner needs to obtain a certificate of occupancy for the residential portion of the building, and then
The estimate
The estimate
must
must.
include a description of the work needed to legalize the building and units and the time necessary for completion of each phase of the building.
What's the official name? Is it New York State or the state of New York? Whatever it is, we should use the official
Or the
name.
state of New York.
I think it's the state of New York.
We just want to read my license before I can this meeting.
Can we add that one more time from the top?
Yeah.
make sure you read it, state of,
State of New York.
I don't know.
Hold on, wait.
An application for an
Also,
extension.
I'm sorry, sir, I think it's New York State, NY.
Yes, New York State Office of the Professions is what registers, licenses,
Okay. So
licensed
okay.
professionals.
You're really good on that.
So we got our Robert's Rules person now, and we got our definition person.
But he needs to stick to Robert's rules.
Otherwise, that's a good idea. I'd be happy to keep quiet.
Next week, you're going to tell Mother not to give me Wi-Fi.
All right, let's move
Like,
forward.
damn, forget the password.
An application for an extension must include a list of all residential IMD units in the building and must include an estimate from a New York State licensed architect or professional engineer setting forth the amount of time the owner needs to obtain a certificate of occupancy for the residential portions of the building. The estimate must include a description of the work needed to legalize the building and units and the time necessary for completion of each phase of the work.
So, you can take out professional engineer, licensed architect or engineer.
Okay.
You go to a professional?
Yeah, so licensed architect, or, it's not a licensed architect or a professional engineer, they're both licensed professionals. So licensed architect or licensed.
That goes back to the thing, because one is called a licensed architect, and the other is called a professional engineer.
So registered architect.
Excuse me, a registered architect, you're right.
Well, but
Yes,
that's
a
the
registered-
license to be registered.
No, but that's.
Right, they're both, and a profession, and an
Yeah,
engineer needs to be licensed too,
Yeah.
they're both licensed professionals.
They're both licensed professionals, it's just that Mr. Delaney's point is a registered architect and a licensed professional engineer.
Not a professional, right? A registered architect and a professional engineer. PE.
Oh, I see. So it's a registered architect and a professional engineer, you're right.
They're both licensed.
Right, so we don't need the word licensed there, is that what you're saying?
Well, it's one or the other.
It's New
So
York
either
says-
it's a licensed architect or engineer, or it's a registered architect and a professional engineer.
So as long as the word New York State goes
Right.
before that, so it's a New York State registered architect and
Or
professional engineer. Yes,
Okay.
thank you.
And then if you're saying that they're given an estimate of the amount of time, isn't it redundant to say that in the second part of the time necessary for completion? Where you want it, it's important that it's
Well,
broken
the second
down by
part is
phase.
the time, the second part is the time necessary for completion for each phase of the work.
Okay.
So, you know, X amount of time for sprinkler, X amount of time for mechanicals, X amount of time for that.
That was a legitimate question, not a comment.
Um,
It was more a legitimate question, not a comment. I'm trying to understand why the distinction. So there's the amount of time the owner needs to obtain a certificate of occupancy, and then in the second part, it says the time necessary for completion of each phase of the work. Why is that important? Why both?
At this point, I don't remember, I have to tell you.
Are you talking about each, is it each, where you described it a while ago, about sprinklers?
Yeah, well, I just,
Is that phase or is that type? So,
well, we could take that
Right,
clause out.
phase would be filing with DOB, contractual,
right, so which one are we trying to accomplish here? Type, work types or phases of?
I don't know, why don't we just end the sentence in units and take out the list? That covers everything. I don't think we
So
necessarily.
that's their estimate of time going forward. Are you also asking them, Michael saying where they have to say what they've done too?
That's the other part of the rule, right? So they have to say what they've done already and why they couldn't comply to begin with. And then here, because this part of the rule goes to how much time are they going to need, right? The first part goes to, are you going to get an extension? But this part goes to how much time do you need?
You're saying it was kind of necessary to have the estimate be chopped up into phases.
Honestly, I don't know, and I'm okay with not having it. You know,
So does the extension, so you're asking for an estimate of time to complete?
Milestones versus?
Yeah, that's what I'm wondering, like, is the extension then equal to the amount of time?
they have to ask for a certain amount of time, right?
And which is this, so if someone comes and says, I've hired an engineer, there's serious structural issues with the building, it's gonna take 3 years to complete all this work.
Right.
I have to relocate my tenants on the other side of the building, I have to shore it up, I have to do underpinning, blah, 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 blah. And so then do they get a 3-year extension? Is that?
It depends on a lot of factors, but they certainly would not get more than 3 years. Depending on when they filed, it could be 30 months. So 36 months is the max, right? Well, 30 months now, but before that it was 36. My guess is it will go back to 36 by then. Okay.
So,
We didn't finish that though. I think we're saying phase, what does phase mean, what is estimate?
No, we're going to take out that, we're going to take out everything.
suggested that
Yeah.
we take after units.
Yeah.
After the word units, we would just take up the rest of the phrase after, and the time necessary.
Time needed to legalize. Do you want to tie it in though to milestones? Because that's part of your.
I don't know. It depends on where they are in the process when they're asking for the extension, so I don't know. Right, like you wouldn't want to say the time needed to file an O1 if they've already filed an O1, right, like why bother? So I think we could just end it at units, I think it's okay.
The only benefit to breaking down the time for various phases would be that might have bearing on the tenants. in the sense that, and might either cause me to, as an affected party, to file an objection or not. For example, the plumbing work in our small building of 3 residential units, the owner asked if we could, while the work was being done on one floor, could the occupants of that floor use the bathroom and the shower of the occupants on the other floor? And we certainly saw the kind of timing headache that came out of that case where we found interference with the time.
Yeah.
So I don't think that having, if there are multiple phases of work, I don't think having some kind of breakdown is such a bad idea.
I don't know, I think if it's going to be hard, if it's not specific enough and the terms aren't good, I'm a little nervous about keeping it in, and I think that people raise good objections. I agree with your point, I'm not sure how I would phrase that. And I don't know that it would affect overall how much time we would give. So, I'm not sure. Whatever you want to do, just write it down.
Well, it provides a clearer rationale and the justification of why I'm asking for 12 months rather than 6 months.
I think you automatically come out, right? In his narrative, excuse me, in his description. So, needed to legalize the building and units to include timelines. What's that?
You're asking me if that would make sense?
Yeah.
It depends what Merriam-Webster says about timeline.
Oh, wait.
Including estimates.
Timelines for each phase?
Well, can't we combine the 2 sentences into 1 sentence, so it includes it,
There are one sentence,
Just 2
right?
sentences.
There's 2, right?
right,
Including
so instead of, let's go back to statement, include a statement from the registered architect or professional engineer, in describing the work required, the owner needs to obtain a certificate of occupancy for the residential portion of the units, and the time necessary for completion of each phase of this work.
Well, let me go back to phases.
But you take the time out of the first one and put it at that. And so it's a statement describing the work and a breakdown of the time needed for completion of each phase of work.
It's a schedule.
And a schedule.
So instead of the verb being estimating, that the architect and engineer doing.
So they're making a
They're
statement
making a statement.
that includes a description of the work and a schedule for completion.
That's easy.
You getting that?
Description of work.
Schedule.
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 You don't like it?
No, I
Doesn't
like
like it.
It's like,
Well, it has to
we went
schedule.
from statement to estimate back to statement.
And that,
I'm fine to let you guys hash it out and then wake me up at the end.
I think we're good. Elaine, can you read that where it's happening?
I'll try. Okay, so it's include the state. Is it a description?
Yeah, a description of the work and the schedule for completion.
No,
No,
you have to
statement.
put in, wait, you have to put in, include a statement from, right?
Yes.
A New York State registered architect or professional engineer that contains a description of the work and,
You could just say describing the work.
Describing the work. Well, then it doesn't,
Describing the work the owner needs to do to obtain a certificate of occupancy for the residential portion of the buildings and a schedule of completion.
okay. So include a statement from a New York State registered architect or professional engineer. Describe, how?
Yeah.
What?
Pretty
New York
good
State,
state.
yeah, I had New York State. Didn't I say New York State?
Okay.
Okay. Describing the amount of time, describing the amount of work.
Describing the work.
The work. Describing the work, the owner,
Required
Required needed. Take over.
for the owner to obtain a certificate of occupancy for the residential portion of the building.
work required for the owner to obtain a certificate of occupancy for the residential portion of the building and
The estimated schedule.
an estimated schedule of completion. Is it of completion or for completion? Of completion. Okay.
Or estimated or schedule.
Well, I put estimated in addition to schedule because it would be hard.
Oh, an estimated
actual
schedule,
schedule.
yeah, estimated schedule of completion.
Okay, I think that's fine. I'll type it up and you'll correct it if I'm wrong.
I like having another architect.
Can we hear that one more time?
Okay, include a statement from a New York State registered architect or professional engineer describing the work required for the owner to obtain a certificate of occupancy for the residential portions of the building and an estimated schedule of completion.
That's needed to legalize the building and the units.
Oh, did I?
Somewhere else.
So we've already got to obtain a residential certificate of occupancy.
Yeah, that's legalizing the building and the units, obtaining a
Right.
residential certificate of occupancy. Okay.
Thank you.
Okay, moving on. All right.
Okay, the rest of it is perfect.
Thank you. Let's take a vote. Smoke a motion.
Okay, so I think I just rephrased II here. This is 3II. Owner or responsible party must serve a copy of the extension application on the occupant of each item of the unit in the building in the manner described in chapter 1 of these rules. Prior to filing the extension application with the Loft Board, after serving the application, the owner or responsible party must file the application along with proof of service with the Loft Board. I think I just rephrased that.
So that tracks exactly what was described in chapter, will be described in chapter.
Yeah,
So why do we need to repeat it here?
well, because we need to know. So you don't want to repeat it? Well, you don't want to tell them? Because here we are putting in, here's how you do this. Right? So I think for purposes of somebody being able to know what they have to do, it's good to have it here as well as in chapter 1. But, you know, we could just put in a general statement that says you have to do it.
Well, maybe in the, part of what I'm tripping over is in the manner described. What we're really saying is following in conformity or following.
Right.
In the manner described sounds a little.
Yeah, plain language, please, which I think we could try. Application of on the occupant of each item date in the building. Couldn't we just say as described in chapter
Yeah.
1?
Yes.
Yes.
I have one little question about that. Based on my real life experience. The other tenants in the building that are not covered, they also receive notification on things like this.
Yes.
So it only says each occupant of the IMD unit, but it's actually everyone in the building.
I have a deep building on that unit.
No, I think for the extensions, I don't know, the others.
Yeah, it sounds odd, which one, it's a concern. Whether, if you don't know who occupies or who else occupies, so do they get notice?
Like I noticed narrative statement for my building, the other people who are not covered received it in the mail.
But the narrative statement is supposed to be served on all of the building residents.
So that one's served to everyone in the
Yeah.
building. And this,
Not every application is served to
this
everyone.
is interesting, I mean, I'm just thinking of those humans that they're affected by this because it's construction they're living with, whether they're covered or not.
Right.
It seems that they should be entitled to know what their landlord's doing, the same way, but
The problem is that if you have a room, let's say you're the primacy, you have 5 roommates. Do your 5 roommates get notice? The landlord may not know who your 5 roommates are.
right, just each unit, each,
So it's a
But-
question, you know, the occupant of each unit is known or each unit? I don't know how to solve that problem. That's a good question.
I mean, I guess even like a commercial tenant on the first floor would want to know if the landlord's getting an extension and going to take 3 years. I mean, he would be interested to read this.
Well, the narrative statement now is the commercial spaces.
With extension applications, I only think you serve the occupants in IMD units, because theoretically, those that are not living in IMD unit, they have their own problems. And we're talking about an extension application where the owner can collect the rent.
But we're talking about the roommates, I think, right?
Actually, I meant out of the unit.
No,
It's like
I think
a
Yeah,
it's
other unit, right.
other units that are
Oh,
not
other
IMD
units.
units.
Oh, okay, I'm sorry, I misunderstood.
I just, for me, it's blurry when those other people that are not IMD unit protected occupants, but they live in the building, when are they notified and when are they not of things?
It depends on what's happening.
So
So,
an extension. that-
you know, if an owner is doing work in one IMD unit, I don't know that they're necessarily going to tell the commercial tenants, hey, I'm going to be working 5 floors above you in 2 weeks. You know, and we wouldn't,
I
because
guess
we're not concerned about that, we're concerned about the IMD units. We want to, in other words, we want to know from the people in the IMD units, should this owner get this extension? That's why we want to make sure that they're
I guess
served.
if
So,
it's-
Doesn't the
I guess I'm-
manufacturing, all the units want to know that the project, just generally, the project is moving forward and that the rental rate is moving
And
forward?
because we file, architects file a tenant protection plan, and that has to do with egress in the building, and if the landlord's going to be allowed an extension, it might have 2 more years of construction, that's thinking, all those tenants are affected by.
so you want to change the occupant of each IMD unit to the occupant of each unit in the building?
Of the building, yes, that's what I'm wondering. I just thought, that sounds.
If
They
they
are
don't.
Oh, yeah, so fire safety.
Yeah.
I actually think that's a
We're
good
not
point.
covered?
I don't think so.
Yeah, I don't know.
Yeah, Martha's making the point that the people who are not IMD tenants don't necessarily have standing to object to an extension, because it really will affect them one way or the other. It's really just a question of whether or not the owner will collect rent. If the owner gets the extension, and the owner stays in compliance with the law for that longer period of time, and the tenants are obligated to pay rent. But the commercial tenants or non-IMD tenants, if they're non-IMD residential tenants, which there shouldn't be, but if there are, wouldn't be affected by that. Which I think goes back to Michael's point.
From
which is
the rent
that-
point of view, but from the life safety or of the building.
Don't you have situations where you have protected units and non-protected units,
Yeah.
but at the end of the day, they're still both loft units, they're still both residential units. So wouldn't I've seen cases recently where the owner is doing significant construction in a building that affects everybody that lives in the building, even though not every unit in the building is a covered unit.
Right.
So I see a safety advantage to every unit being notified, whether it's a protected unit or whether it's not a protected.
I guess my concern is notified of what? Of the extension? Or I mean notified that there actually is work that's happening in the building? I mean, owners are responsible for posting permits in the entrance, right? Isn't that
Yeah.
a building requirement? So they're aware that work is happening at that point.
But the permit doesn't really say what the work.
Neither really does the extension application, only to the extent that we just added in this description and estimate, but the extension application really doesn't say either.
But the narrative
The narrative statement
does.
That's why-
And the narrative
That's
statement
why
is
everybody
required
does
to
it.
be served on everyone, so that everyone is aware of the work that's happening in the building.
So
At some point.
whether
not
we do it
necessarily-
here or whether we do it at some other place in the rules, everyone in the building is being notified.
Absolutely.
Yes.
And then the building code and the different rules of the cities, they have to notify their tenants 24 hours before you're shutting down the water, and like all, there's all those very specific notifications
Well,
that
I
happen
guess
during
I'm actually thinking of a very specific situation that the light came on with this, but I was recently in a building that they were doing significant jackhammering on the roof. And I'm telling you right now, I was even amazed. There was nobody doing anything peacefully in that entire building that whole particular day. Well, what troubled me even more than that was, the closer you got to the areas where they were actually doing jackhammering, the dust
Yeah.
created a tremendous health issue, in my opinion. So I'm just concerned as kind of like the safety voice, that we make sure that all the tenants are being notified at some point. So they have the opportunity to do whatever, take the baby and go shopping for the day, or do whatever the case may be. Not going to necessarily be perfect, but again, like I said,
Yeah, I would back that up, I mean, so I live in a building where the tenants change all the time. So a narrative statement might have happened in 2014, but like the new tenants have no idea what's going on in the building. And so even the fact of that they are always included, hopefully someone picks up something's happening. Because communication is not necessarily happening between the landlord and the.
So I'm not sure if I'm missing something. Are we talking about IMD? You're talking about IMDs versus non-IMD units, right?
Yes.
Right, and whether or not the non-IMD units should get notice of the filing of the extension application.
So do we have governance over that?
I didn't know if overall in the rules there is something that,
I'm wondering.
I don't know if it's a question of governance so much as notification.
Because that may come under tenant protection laws that are already existing. I'm just wondering if the loft board should be putting those things into where all rules are ready already in the code, in the building code, and so on, that requires that. Just wondering, does it belong in our rules also?
That's exactly the discussion.
yeah, that's.
Oh, that is it?
I mean, that's
I'm sorry, okay.
No, but we're wondering, like, I'm just wondering where the decision's made that it's going to IMD only or the whole building, because I noticed on the narrative statement, a neighbor who's not allowed, who told me they received it. I didn't know why they would receive it. I just think that, is there like a matter of fact, and it might come out of some tenant protection, that is just de facto, like for every New York City resident.
if the building is under our jurisdiction, however, wouldn't it seem that we have some sort of onus on us as the loft board to look out for the overall welfare of everybody, whether it's a regular
But
tenant?
by that took, this is IMD, it's intermediate, so it's always.
But this is just pertaining to the extension, okay? so the owner wants an extension of the code compliance deadlines. The owner will work or not work regardless of whether or not they get the extension, because even if they don't get the extension, they're still supposed to legalize the building. So who do we want to reach with this? We want to reach the people who would have standing to comment on whether or not the owner should be entitled to the extension, and that's not the non-IMD residential tenants or the non-IMD commercial tenants.
It's sort of opening the bigger question of how much notification should all tenants of the building be given of the various steps of the process, which is complement to the issue of poor construction practice, because the tenant protection plan says you can't have dust migrating outside of your construction. So, right, you're supposed to seal that up. And so while that could be looked at in and of itself as a violation, specific violation, someone else, if the dust is migrating, someone anticipated that this type of heavy work was going to be happening on this date based upon a overall timeline provided by the owner through all these different processes that's now been extended, so on the extension rule.
Maybe.
So maybe extend. So it's sort of part and parcel with like how the building goes from point A to point B and who the various people affected by this are.
What are your thoughts, Jim?
I mean, if the board feels that we should expand this, I have no problem with making the owner serve everybody. I mean, that's what you want to do.
Well, how many times are we serving people? I don't know. I'm just wondering,
yes,
if it's like a wholesale, like.
Instead of focusing on this as an extension thing.
Let's keep in mind, if there's legal work going on, they have to serve these notices, right? If there's legal work going on, the permit is in place and the permit is extended, then these notices are already out there. So, again, I'm conflicted because I'm not sure if we're expanding our reach through this.
I don't want to expand our reach, but I do want to say that these are buildings that are not legal that people are living in, so there's always a safety concern. And just from my own experience.
The non-IMDs are legal, right? The non-IMDs, not necessarily? Yeah, okay.
Well, I guess my whole thing is I'm sort of hung up on the point that the building is under our jurisdiction, which means that yes, there are protected units within the building, but the building itself is under our jurisdiction. So,
But it also goes to the building may be covered, but is the unit covered? Well, if the
Unit
unit's not
specific,
covered,
because if the heat sprinkler system in the second to the sixth floor where people are living, what about the commercial unit in the first floor? Would they be required to get the sprinkler system from the inside? That's my question. Not necessarily, so I mean, I think the commercial, but there should be a sprinkler system. If it's going to the whole building, there should be one in the ground floor as well. Don't you think?
typically, you're going to have a sprinkler system in the commercial before you would have it in the residential.
True.
Is that so?
That's correct.
So if somebody is operating a commercial within a building that's under our jurisdiction and it doesn't have a sprinkler system,
Yeah.
that's probably going to happen before. But some of the buildings that are coming into my mind are sprinklered throughout. So the commercials have sprinklers, and the fact that these old factory floors had sprinklers on them as well. So now are you saying that, and I don't know, we're just talking here, but are you saying that the sprinkler only has to work on the second floor because that's the only place where we have an IMD unit? Or does the sprinkler have to work in the whole building because the building is under our jurisdiction? Don't misunderstand me, Mr. Chairman, I'm not saying I have the right answers. I'm just saying of how I view a building under our jurisdiction, I take it very personal that the building is under our loft, it's a loft building under our jurisdiction. And when something comes into the fire department, as soon as they see loft building, they come from all floors to Roach and say, this is your building. And so I'm just wondering if that sort of puts an onus on us to make sure that that communication flows. I don't know, I feel kind of like we're only providing, or only enforcing communication in the protected units.
Just in the, but the non-protected units get a lot, or the non-covered units, let me put it that way. They do get notice of a lot of things, and we could actually add more tenant protection type things to 201 if you wanted to, but I don't know that it necessarily belongs here, but I would like to.
The question is whether we're serving to every unit.
Right, that's what the issue is. We're going to service to every unit, including units that have no standing to be attached, or are we going to?
How onerous is this to serve in general?
Depends on how big the building is.
When you say overreach, I'm interested in that, but I'm also thinking, not thinking of overreach for a minute, just the idea that the least protected person is actually the tenant living there that has no IMD protection. That's still a human that we don't want hurt in.
Well,
Or to breathe in.
Let me put it another way. A 6-story building, the top floor is a fashion, the pocket for fashion shoot. No IMD units. It's a fire. Sprinkler system on the 5th floor all the way down. There's a fire on the 6th floor. Sprinkler system on the 5th floor is not going to help very much unless the smoke or the fire gets into the 5th floor. So it seems to me, in order to protect the IMD tenant on the 5th floor, that 6th floor, which is a commercial space, has to have Article 4, Article 7, Article 5. You know,
Right, there's certain commonalities.
I thought that one of the most important things about the legalization of law was Article 7A to make these buildings
Article 7B.
7B.
Yeah.
This is just notification, right? We're not
Right.
just serving. So what's,
I understand.
are we serving with, like, is it, who's serving?
Owner
The owner serves by
Is
mail.
he serving as giving or serving going through the
Mail.
entire like,
Mail.
complicated process? of
Mail.
serving?
Mail, with a certificate of mailing.
Like, I don't understand the issue here. Like, I feel like we've talked for a while, I'm like, if we want to notify the city work guy, if we want to notify the least protected individual, let's mail everybody something.
Yeah,
I don't think
that's what I'm
right.
saying. And
Yeah.
unless it's overreach that we're giving too much information.
I don't think it's
about
so much
the
information.
My only concern about the word overreach there, but I said it was because I hate, we should all hate to put things in that we cannot enforce. And so, why put language in, and I don't know if we can, that's what I was asking council. So if we can't make enforcement, because we have no jurisdiction over these, which I'm trying to get at, then we shouldn't, but.
So if we say, enforcement perspective, if we say must serve to every occupant within the building, and we get challenged on it, the challenge will ultimately come down to saying non-IMB units can't get it. We tried, at least the IMB buildings are.
But we still have to pass muster about it.
But what do we do with the answers if the non-IMD tenants, commercial or residential, actually send us in answers? What do we do with that? I mean, they're really not in a position to challenge whether the owner gets an extension of the code compliance deadlines, because the code compliance deadlines don't apply to them.
And the reason why you serve them is for them to have the ability to challenge. So,
A circumstance to that is, an owner may then say, well, a tenant in a non-ID unit shouldn't be there. And then if an owner's saying, well, if I have to serve everyone now, they may go to court now to evict that person that they had no problem with, in fear of receiving an answer that they don't want the owner to know. The building is an IMD, the unit's protected, people can live there. But in a non-IMD, there's no C of O. So technically, the law's not protecting them.
Right.
It shouldn't be.
Which I guess I'm thinking of their perspective that they're living in fear kind of
Right.
every day, like is construction going to start tomorrow? It might not start for 10 years. Like everyone's always in this.
But this is an extension, this is not actual work.
I don't want to get them evicted, but I also feel like they should know
whether the owner's trying to get an extension to be able to collect rent. And a person who is living in a non-IMD, he may have that problem already because he's not protected by the law. An owner could go to court to evict him for non-payment. He's not protected by our rules.
Good point.
Okay, so I know we're not allowed to talk about cases, but we have an issue right now where we have a building that went from one status where there were two different types of people in the building, ones that were writing rent checks out, just like I write my rent check out, and other ones were protected units under the Loft board. The building appears like it's going to swing the other way now and lose its CLO and come to protected status under the Loft board. So, isn't there some sort of onus on us as a board if we're saying the building is coming back under our jurisdiction to advise the people that are living there that aren't living in protected units what's going on with their building or not?
Advise them of what? That the owner is going to be able to collect rent from the other people who aren't paid?
Well,
That's what this is about.
But I brought this up in the beginning because there was talk about if construction is going on in the building and all. That's what actually perked my ears up.
Yeah.
Because right away I like the whole pothole because I just.
You don't think it's that?
So if this is not the area, then, but there was discussion that perked my ears and I heard somebody saying about notification of construction or different.
So it's not notification of construction here, and you're right on that if it was. It's just notification of an extension to meet a code compliance deadline.
I mean,
So you're right on that if it was that, but it's not. But so we just,
Okay.
so what Helene is trying to say, what he articulated earlier, Michael, was that the only people who are affected by this notification are IMD tenants.
Okay.
And
That's
therefore,
an application.
yes,
But there's no doubt in the narrative statement, we're doing work all the building, 100% every occupant should know, because it's probably going to be work in their unit to bring it up to code. In Mr. Burroughs' example, the 6th floor, yeah, on the 5th floor, it's a residential building, the code says sprinkler the entire building, a fully sprinkled building. Or build fire
Forgive me, but I
rating.
missed somewhere there we transitioned. Like I said, I know we were talking about construction being done, and extensions being filed, and
Well, I think because we're reading in, you're thinking that they can charge rent and that's why the IMD is seeing it. I'm thinking of if someone's going to be allowed to construct, they're in construction now and maybe they thought they'd finish in 3 months, but now they've got an added year to finish.
Right.
That construction, sort of like the Warren Street decision, that construction affects tenants' lives in terms of.
see, that's what I picked up on. Somebody
Yeah,
said
that's
that
right.
construction.
I'm pointing out that part, but maybe.
So this would put those tenants on notice that the construction might take longer.
That the
Okay.
entire application has been processed, the entire process, the
being
legalization process
extended.
is being extended, and that they can plan their lives accordingly.
You are the board, whatever you would like. Just let me
Well, but
know.
I mean, shouldn't everybody have the right to know that?
Because it's very disconcerting when you don't know if your construction is.
they would know, the
years.
other tenants will know
Under another set of
another
circumstances.
set of circumstances.
But where would they?
Here, should you be sending out this notice to everybody, it may even throw confusion
Okay.
to non-IMD tenants.
That's why I was wondering, like, is there just an overall sort of what you were saying, like, can we just, every time there's something triggered, it's sent to everyone who lives in the building? Or are there IMD things and are there,
I mean, it depends on the kind of application, right? You're talking about who's an affected party, right? And I think here we have a difference as to who would be affected because we're viewing the effect here as the owner gets to continue to collect rent or to collect rent, right? Whereas you're viewing the effect as something else.
Safety.
right,
Right.
because we
So-
all pay rent. So we're in that, from a personal perspective, we're paying rent no matter what, so
Right.
in my case. But so I'm thinking construction's the disruptor, that's not, no one wants to breathe in jackhammer dust.
Right, of course.
Yeah.
Again, everybody, but I don't.
Let's
I
make
don't
what's sensible, let's do what's sensible.
Yeah, no, I mean, if I'm understanding correctly now, I wouldn't advocate that you send to everybody, and I don't believe I'm being misled, so.
But,
As long as they're notified.
But look, we just decided they're turning in an estimated construction schedule. That would be the most concrete information a tenant could ever get out of a landlord. There's,
I agree with you, but now what concerns me is the part that Elaine said is like, okay, I'm not an IMD unit, I'm not an IMD government tenant. What am I supposed to do with this? And if I do send something back or fill something back to them, now we've opened up a whole new question. What does the loft staff do with it? So, I mean, I sort of see where as long as with our safety concerns are covered somewhere else, which they're covered in the narrative statement, then in this case, even though it might not seem like a big deal, it might really cause a quagmire if somebody starts sending stuff back and what we do.
what if somebody objects, and what if I'm the next door neighbor and I catch wind that something's going on and I look it up and I find out this is, and I object?
I don't know that you don't have standing to object.
Chuck, what's the historic
Why-
Not on the
then
law,
why-
not on the law.
You don't have standing to object to the extension one way or the
Or
other.
if you're looking
Then
a cup of
why
coffee
does
about what you're
the
thinking about.
commercial tenant have standing? Because they're in the
The
building?
commercial tenant does, in the context of extensions.
Yes.
The only people that have standing to object to the owner getting an extension are the IMD tenants. For the narrative statement.
So I guess my point or my question is, why is the ground floor commercial tenant responding to the letter any different than the guy across the street? I mean, if neither has standing, then neither has standing. You don't do anything with it.
But aren't you then giving them an expectation that they are getting some sort of due process to which they're not entitled to? I mean, I envision this as, they send something in, let's assume we grant the extension, and then they're really upset that the extension was granted, and they file an appeal, and then they sue us, and, and they never had standing to begin with, so.
when these come in the mail, they don't even have a letter explaining. They're just like the thing sent.
No, it should have, when an
Says-
application is served, it's supposed to have an instruction sheet and an answer form.
Doesn't have
Well, then you have to yell at your landlord, but it is supposed to, requires it.
It's just like an envelope with a thing, and you think, oh, I get to see this, but I don't.
The narrative are you talking about the narrative statement, or are you talking about an application? The narrative statement usually has a cover sheet with an explanation, but the application, they're supposed to attach a copy of the answer form and an instruction sheet. They're supposed to.
Never.
Chuck, were you going to say something?
I understand the merits on both sides. Obviously, and I'm very sympathetic to the situation you described where there's dust spewing around a couple floors of the building and a huge racket, which reminds me of getting a root canal. And if I make an appointment to see the dentist and then I postpone that appointment, that doesn't really, the real pain is when you get the root canal. So I don't know, I think putting people on notice is great, but I don't know if the owner's applied for an extension, here's the extension and the summary, doesn't tell me that the day I should take the baby and go shopping is 7.5 months from now. So I think we could think about, particularly in these bigger buildings where you've got, let's face it, a mix of what could be market rate tenants who will undoubtedly be expecting to be treated in a market rate kind of way. You could have IMD protected tenants. Then you could, and part of the reason that the 2010 extensions are so screwed up, you're going to have a lot of tenants who are living there but can't be covered, but the owner's not going to throw them out because he likes the rent flow. So you really got a whole different group of people. And I think, particularly in the bigger buildings, we need to take a look at how best to try to provide for the safety of everybody, because, but whether that's at this point in the game, and I understand Jolene's concern, if I get something that makes me think I have the right to object, but the truth is I don't, you know, as Heather says, the guy across the street. So I think this might be something we should look at somewhere else in the code compliance rules.
I would send it to the guy across the street as well. And my, well, my point is, the more people that, there are so many people in this city that have no idea what the law board is, what it does, right?
Right.
And I get this question all the time, and they say to me, what? Right? So I think, at least in that building, the more people that know that this is an agency, sanctioned by the state of New York, administered by the city of New York, it's an official group. And most people don't even know it. And some people say, I'm on the law board, it says on your building, you know?
So,
I live in the
Yeah,
law board.
right.
so are you in favor of this language, the way it is? Just
No.
need, I know what I'm trying to get, you know.
Oh, I'm good with the language that we've discussed here in the last
Yeah,
hour.
honestly, I think we should leave this IMD in there, or, you know, for purposes that we think. Is anyone opposed to that? Okay.
Well, can we get, can I have, sorry for my, it might be a name already, when in this process are notification, who is notified? Is there a list? Is there a checklist?
You mean of notification requirements?
No.
Or in this process? yeah.
So this discussion that we're having, I
Okay.
think would make more sense if we understood the bigger context. So let's start from the beginning. Landlord, owner files to legalize the building,
Well, I
right?
think you should start with coverage, in which case a tenant applies for coverage and they're required to serve everyone.
Everybody.
Everyone.
Okay. So
Then that process goes out and everyone's getting
it goes
covered.
completely, so as soon as somebody starts the process, the entire building's on alert anyways.
That's on the tenant, yes.
Okay, and then,
Let's say the building goes through coverage, becomes an IMD building.
2 years later.
2 years.
The
10
sign
years,
goes up, it's
whatever.
supposed to go up.
The sign goes up on the building, now it's an IMD. Now an owner has to legalize. The owner prepares this narrative describing all of the work, and that's now served on everyone. Now, those people are then invited, the conference, the narrative statement conference is sent out to everyone. The law board invites everyone to these conferences. Not everyone shows up. Sometimes some show up, sometimes no one shows up. Sometimes you get a person living in an IMD who shows up.
So even the guy across the street can show up if you want to.
Rarely ever do not IMD.
Can the guy
I don't
across the
think they
street show up?
understand that.
I'm thinking, I'm just, you know, we're just
They're circle. And once the narrative statement goes through, I mean, here we're talking about an owner trying to basically collect rent from his IMD tenants. The issue is non-IMD tenants, they may be required to pay the owner, or the owner goes to court. Like I said, they have other issues. But this is solely to collect money from the IMD tenants. Other applications, you don't need to serve everyone.
Right, issue of collecting rent does not affect the non-IMD folks.
But so far, we didn't talk about how you see that rule as solely about collecting rent. We were talking about
Oh, well, that's
extension
what,
for good faith.
that's what
stuff.
it is, that's what the
From
extension.
your perspective, right, from our perspective, I mean, that's an important thing to remember, that,
Yeah.
that tenants would have to start paying rent. That's one
Yeah.
piece of it.
That's the major.
You're seeing it as the major piece.
Yeah, that's the purpose of the rule.
That's it. This is what the owner is.
Respectfully disagree with that. In many instances, the tenants are paying rent, even
Yes.
though the owner. So the main purpose of this is to get to code compliance
And-
and keep us from finding his ass, right? Which
Yes,
we should
that's
be
true.
doing regardless of how
Yes,
the tenants.
that's true.
so I think I would vote then for notification based on that, because the whole building's already involved anyways, everything's on the table.
Yeah,
This is just one more piece, it's saying that, well, you know what, we're giving it another 3 years.
just more transparency for what but from a tenant's perspective,
As I said,
because you're seeing the case, but the timeline is like decades, and the buildings change over, tenants are changing over, because they don't have many needs in the city to survive, and they're constantly turning over. And they have no idea what's
Okay.
this process is about.
I just want to add to that, I don't know if a non-ID tenant getting this extension application will really help them to understand, rather than the more important application is the coverage application, or the more important application is the narrative statement. It's an extension application.
Could they get in there, and let's say they moved in, they get that thing, they're like, what the heck is this? And they get in touch with the Loft board info, and then you say, well,
Our
you're.
first thing, our recommendation is to foil the folder, read the
Yeah,
narrative,
that's great.
100%.
That's like more public information. That's what I would want it to trigger, aside from helping subside their daily fear of like, is our building about to be wrecked with construction and I have to live in and construct, you know, like you don't know when it's happening. Is it happening next week or is it happening in 5 years?
Are you having the same sympathies for commercial as well as residential?
Oh, I don't know.
Because what you're asking here is that for us to serve, to serve everyone, correct?
The same as the narrative statement.
Which includes commercial, right?
Mr. Chairman, I have just a suggestion. Since I sort of, he's starting to get the feeling that we're heading to the final wind down here for today anyway.
We're going to 6.
Oh, we're going to, okay. I was just going to say, I would really appreciate, I really sort of see the picture now, but I think it might be a good idea for the staff to come back with us, to us on February 14th with the legal concerns that might be involved in notifying everybody, because
can we make that February 21st? I really want to vote February 14th to protect
I'm okay with that if everybody else is. Because I am concerned about the component of, I'm not protected, I send this back, and now what does the staff do with it? You know, we really have to sort of look beyond that, and I don't think we're going to hash.
Okay, staff will do it if you ask for it, but I mean, again, I just think that it was kind of.
Could you also send them form they're supposed to get?
If you got it.
I've only seen like, I thought it was kind of just an informational. I never thought there was like.
Answer form and the instructions.
Yeah, the answer instructions, I've never seen.
All right, she's asking you to give me a copy.
Yeah, okay.
That would be
So
great.
you're going to shoot that around?
Let me ask one question. And the concern is a fair one, that if you send somebody a notice where they don't have standing, and they fill it out, what do you do with it? But you want people to generally know, would an alternative be to require the landlord to post a copy of the extension application in the public area?
I don't know, because they're,
You mean once extended, once it's extended, or?
no,
The application?
the application is usually multiple pages, and it could have the architect documents and whatever, so I don't know. It's a thought, though, give notice some other way, or do we have a separate application for extensions?
Yes.
Yeah, so we could actually put on the application for the extensions, we could make them mail it to everybody, but we could say on the application that only IMD tenants
So this
can respond.
This
You know,
is
we
for
could do it
information
that way.
it's only applicable, I mean, for purpose of response or whatever, it only applies to interim dwelling tenants, right?
How about if
If they understand that.
sorry, how about if the application is approved or granted, so that the person would know when the owner is supposed to legalize?
After, I mean, the notification goes
After the
out.
fact.
Putting the post before the carriage.
Yeah, that would be,
Yeah, that'd be great.
you mean a piece of paper goes out to
No,
everyone in the
the
building
decision.
after the extension?
The decision, I mean, the decision written, the administrative determination that is written after someone files an extension application could be posted on, in the hallway in the public area, that tells tenants what the new dates are and why they were extended.
So that would be on the owner to do it. So
That would be, right, that would be required.
Like within 14 days of the mailing date.
Would that be the same?
You would have to make another I, or you just put that in a sentence?
No.
No, it would be
If
the
you're
actual
required, you gotta put it on
decision.
the rule.
But when you want it posted, you want it posted in the building or you want it mailed to everybody?
Mail.
No, I would post it in the building.
How long is it?
I would mail because we only have separate commercial and residential. So think of it from like a store or a small manufacturer on the ground floor, point of view, right? Maybe they don't want to be there through construction and they're like, so I'm putting out a 5-year business plan and it includes moving when this building goes into construction. Now, I need to know, is that going to happen in 6 months, a year, 2 years, 5? Like, should I sign a new lease? Should I sign a 10-year lease? Should I be looking for space now? Should I be watching the market? How much is it going to cost me? Like, it could be $100,000 to move the business. If you have equipment and you have this and you have that.
The L tree.
So, that's right, the L tree, yes. So
That's
it's
not
all-
gonna
There's different components to this that could, really affect someone's livelihood.
So how about just another sentence that within 14 days after the decision is rendered, owners shall mail out a copy of the decision granting the extension, if the extension.
Well, it wouldn't go here, it would go
Somewhere.
after, yeah, it would go in the next
In
section.
the next, wherever.
We could add a requirement.
Yes, that sounds great.
That'd be good.
Yeah.
Okay, I think we deserve a break. I mean, we just go, we need to have a motion.
I'm a 6 o'clocker now. When you say 6 o'clock, I'm holding you to that, Chairman.
Okay, you and I have a one-on-one. So let's, we did agree that we will vote on the changes that were discussed.
I didn't know we could vote on it at the very end.
Yes,
We don't have to do it.
yeah.
Okay, thank you, Mr. Roberts. All right.
At the very end, and like.
It has to get rewritten.
Yes.
That's right.
Yeah.
That's right.
Are you contemplating ending the meeting?
Ending that.
I am contemplating unless you have a,
I just have one question.
Sure.
The February 14th meeting,
yeah,
where will that be held?
Reed Street.
Reed Street.
Reed Street.
Yeah.
Okay.
And
Now,
that's-
when are
that's-
these lawyers coming?
14th.
14th,
They're coming.
yes.
Yes.
Okay.
Are you going to be able to do that?
And
Yeah,
then,
yeah, no, my.
and that's the extra meeting, and the
14th.
regular lease.
It's the 21st.
Meeting is the 21st.
Yeah, and the basis on that.
But maybe it'd be a good point to reiterate that 1 o'clock start time thing.
Yes.
I mean, everything starts at 1 o'clock now.
So the meetings, for you, the board members, the meetings always at 1. Whether it's the public sessions, we only start at 2 if we're going into we're gonna have a private session.
But we'd still be here at 1 for an hour of private.
Private,
and then go-
right. So that just kind of, let me just make, that's an announcement, because I think we made an announcement last time that we are working on some sort of a system where we can quickly notify the board and the public, of changes to stuff. We're going to update our website and create a listserv. Are you aware, for those of you in the construction industry, you're quite aware of the notification that DOB sends out when high winds occur and tell the crane who has to take their cranes down or so on. It's similar to that, where we would, if people sign up for with their email addresses, that any change, notices of meetings or changes to meetings would just kind of go out as soon as we have that information. So we're just trying to do that to be more transparent and correct our mistakes quickly. So that's happening. All right. Are you prepared for something?
There to go. Still have more work to do. Sure.
Any other thoughts before we close? Okay, this will conclude our January 31st, 2019 Loft Board meeting. Our next public meeting will be held on February 14th, Valentine's Day, 2019, 1 p.m. at 22 Reed Street, Spectre Hall. Now, that is 1 p.m. for the public meeting, because there's no private meeting. Thank you, board members. Please remember to attend. Thank you.